I'm going to call this meeting to order. Welcome to the Senate Committee on Growth and Infrastructure. Secretary, will you please call roll?
Senator Buck?
Here.
Senator Hansen?
Here.
Senator Deontay?
Here.
Senator Pizzino?
Present.
Chair Nguyen?
Here. Everyone is present, and for everyone that is joining us in the audience here in Carson City, we do have two rooms. There is an overflow room at 3143. However, if you do want to come and testify, you will have to come down to 2144. We do have quite a big agenda today, so when at all possible, you can say me too, I agree, I oppose, and you can always submit any additional comments or more extensive comments in writing. And with that, we will jump into this. I was going to start with Senator Scheibel's bills, but I'm gonna probably kind of go in and out of order here. So I am going to start with Senate Bill 416. And if we can call Andrew Bennett up to the table. He is the chair of NVAX, and I believe he has someone else. So I will let you guys go ahead and begin when you are ready. Again, please state your name and spell it for the record. And every time you speak, remind us of who you are again.
Good afternoon, Chair Nguyen, Vice Chair Pizzino, members of the Senate Growth and Infrastructure Committee. Good afternoon. For the record, my name is Andrew Bennett, and I have the privilege of being before you today exclusively in my capacity as chairman of the Nevada Advisory Committee on Traffic Safety, and it's a privilege to be back before you this week. Just by way of background, Senate Bill 416 originates from a joint interim standing committee on growth and infrastructure, BDR, at the request of NVAX, and I'm pleased to present today SB 416, which provides revisions to programs related to the 24/7 sobriety and drug monitoring program. With me today, I have the privilege of being joined by Judge Scott Pearson, and our hope is to be brief, but to give you a clear explanation about the program and what we hope to achieve with this bill change. And so to give a history of 24/7 and what we're hoping to achieve with this new driver's license change, I'll pass it over to Judge Scott Pearson.
Good afternoon, everyone. Judge Scott Pearson for the record. I want to thank this body for taking up this very important measure. It's been very important to me for a long time. I will try and be brief. In simplest terms, my job as a judge in sentencing an individual is to fashion a punishment that keeps them from coming back, basically, in a most effective and fair and just manner. And it's nowhere is that more important than impaired driving cases. Impaired drivers kill more than 13,000 Americans every year, one every 37 minutes. When you add to that those individuals that are paralyzed or substantially harmed, it's at least 4 times that figure. So every few minutes, someone in America's life is being drastically changed by an impaired driver. And nowhere in our criminal justice system is that issue more important than impaired driving, because it is the recidivist DUI offender, the repeat DUI offender, that's responsible for a disproportionate amount of those fatalities and those injuries. So there's no other crime that we have that has that direct correlation. We certainly have too many injuries and deaths from intimate partner, but the numbers don't compare to driving under the influence. And there's no other crime, misdemeanor or felony, that has that great of a risk to the community for recidivism. That's the bad news. The good news is we have some very effective tools, and 24/7 is one of them. There are many studies that are part of this body's record from previous times that the 24/7 bill and program has been before you in many different states. Significant reductions in fatalities, injuries. Even in some jurisdictions, they see reductions in intimate partner violence and child abuse cases because of the reduction in people that are making poor decisions from drinking. So what this, again, the legislature saw fit to enact this program many years ago. I was here and part of that. What this change is very minor. Currently, if you have an ignition interlock device, there's 2 choices for the judges with regards to your driver's license. Either an ignition interlock device or the 24/7 program. The ignition interlock device is called a privilege. That means if you have it installed, you can drive wherever you want. But the 24/7 program, unfortunately, and I'll take responsibility for it since I was involved in the drafting of the language, is a restricted license. And so that means while you can go to your scheduled doctor's appointments, you can't take your kids to their doctor's appointments. You can't go to emergency doctor's appointments, theoretically. You can't go to the grocery store. Or if you do, it can only be 1 or 2 on specific days that are pre-approved. So it creates significant burdens for individuals in our criminal justice system to comply with the law, basically. And one of the primary benefits, ignition interlock is a valuable tool, but we're seeing controlled substance impaired driving increase significantly and the fatalities and injuries from that. And unfortunately, the technology in the ignition interlock device does not test for drugs. And so this allows us to capture that about half of repeat offenders that use controlled substances regularly. It allows us to effectively test them as well, where the ignition interlock device doesn't. And then for high-risk individuals, currently our ignition interlock device, it just saves the data in your car, and you go in every 90 days and have it downloaded. Well, I don't know about you, I'm married to a school teacher. She wouldn't address an issue with a student 90 days after it occurred, right? So we want to take what we've learned from the science of behavior modification and address the issue as soon as possible. And we want to address it therapeutically if we can. So we want the treatment provider to know this person's still testing positive, where that's just not happening for our high-risk offenders with the ignition interlock device. And this 24/7 program, because it's daily testing or it's the random drug testing, allows us to do that. It also is run by law enforcement. So we have the ability for those true high-risk offenders who just aren't complying and are a great risk to the community, law enforcement's involved, rather than DMV simply resuspending their driver's license. We have individuals in this state under that program that have tested positive hundreds of times and haven't made the serious changes they need to make in order to stop putting themselves at risk for the community. So this simply makes it an or, ignition interlock, privilege, or 24/7 privilege, not restricted license. Thank you.
And so with that, Chair, I'm happy to walk through the key provisions of the bill or go straight to questions.
I think we can go straight to questions if that's okay with the committee. Oh, but it looks like Senator Buck would like a little bit of a walkthrough, so why don't we go ahead and do that?
Absolutely. Thank you, Andrew Bennett, for the record. Section 1 creates the new 24/7 privilege for your license and requires the Nevada Department of Motor Vehicles to issue these licenses to program participants upon receiving certain notices from the courts. A 24/7 privilege permit allows a person to drive freely to any destination of their choosing, provided that they're a participant, an active participant in the program. Sections 1, 3, 5, 7, and 8 make conforming changes, replacing the term restricted driver's license with the term 24/7 privilege. Section 2 and 3 defines the 24/7 privilege. Section 4, 5, and 6 clarifies that testing for alcohol and substances can be used with methods that are federally approved under their regulations, not just in-person testing, and provides that the flexibility to counties and law enforcement and the participants that are especially in rural areas to use remote alternatives with the technology that again meets those federal standards. And then Section 8 ensures that all legal references to restricted driver's license are updated to 24/7 privileges. Essentially, as the judge said, our hope is, and through a question, the judge would be happy to answer exactly how the 24/7 program works. But I can tell you, being a part of the team that looked at this, in the mid-2010s, this program combines immediate testing with services and that immediate accountability. Our hope, though, is to ensure that these people that are participating in the 24/7 program have the same ability to have that license that those do in the ignition interlock program. And so happy to answer any questions.
Go ahead, Senator Buck.
Or you'll take mine, Ira. Thank you, Chair Nguyen. How often are they tested?
So for alcohol, it's every day. The program's based upon a program that started more than two decades ago in South Dakota, and it was in-person PBT twice a day, before they go to work, after they go to work. And so they call it blow and go there. It's $1 per test. Now with the controlled substance, we've added the urinalysis. We also have remote testing that is accepted by the federal government under the 24/7. So there's a watch now that is a transdermal test for alcohol. There's the old ankle bracelet that people are aware of. And so there's many tools. There's kiosks that we have in Washoe County that people can go to in remote areas that can assist them as well. So for alcohol, it should be every day because it dissipates through your system so quickly. For drugs, the gold standard is 2 out of every 7 days, completely random, including weekends and holidays. And so our program from the start was open from 5:30 in the morning to 8:30 at night. So no one ever was forced to make a choice between their job and testing. 5:30 in the morning to 8:30 at night. Anyone can make those hours in order to be in compliance.
So they have to go before and after work? So-
For the record, Scott Pearson. So Yes, if it's the random drug testing, and we do have an 80-hour alcohol test we can use as well for some individuals. Again, it's not as effective as that daily testing. We have a handheld device that just Bluetooths off their phone. It's only $2 a day, so that they get a notice even if they're at work, and then they can excuse themselves on their break and provide that breath test. So we provide a very convenient means for them to do it. And I believe, I don't want to speak for them, but the last 2 times this bill was before, and each time it passed, the Public Defender's Office was in favor of it because it's actually much easier for their clients to comply with than the ignition interlock device that can be a lot more costly and a lot more burdensome.
Thank you so much. My sister, about a little less than a year ago, was almost killed by a DUI on his 5th offense. And she had 5 inches of her colon removed. And so anything that we can do to keep these dangerous people off the roads, thank you.
Thanks, Madam Chair. Actually, that was my question. When people enter the monitoring program, how often do you have individuals that cause accidents while impaired?
Oh, incredibly rare. I think our test results off the top of my head for the breath test, it's 99.8, something like that, are clean. So, and it also builds this great relationship between law enforcement. So we went and saw it in South Dakota before we implemented it here. And to see probation officers say, hey, great job being sober today, have a great day at work, to build that relationship and to have those people have that positive reinforcement from a figure like that, it's wonderful. So the results of the program, and there's the RAND Corporation, there's many studies that show it's South Dakota, North Dakota, Wyoming, Colorado has legislation but doesn't use it much. Montana does. Washington has some legislation, uses it a bit. So it's very helpful for if you're trying to lose weight, you got to get on the scale every once in a while. And this is the same thing for people. It helps them be accountable. We know structure and support is what these folks need while they move through these programs. And that's what this provides, rather than some test in your car that goes to somebody in 90 days that maybe just resuspends your license. And there's not an effective change of behavior for those dangerous repeat offenders.
Oh, great. That sounds fantastic. In fact, that's the best report I've heard on any government program so far this session. So thank you, Madam Chair.
I just have an update. You know, I remember when former Assemblywoman Jill Tolles brought this legislation and then cleaned it up again in 2019 and again in 2021. You know, I saw the benefit of this program, especially based on, like, it's a very proven, like, evidence results-based, like, program. So I know it is currently utilized in the north. Have any of the judges in other jurisdictions kind of expanded using the 24/7 program?
Scott Pearson for the record. Frankly, we've been holding off because of this burden of having to do either this, it's a 5 to 7 page application where, again, you have to list the 2 grocery stores, the most direct route to them. You can't take your kids to the doctor. So I, as a judge, even though I believe in this program so much, I tell people you should probably just do the ignition interlock device. It is so much easier than this application and the restrictions that are going to be on that license. So no, we have held off since Assemblywoman Tolles brought this bill in expanding it until we get this fixed and people don't have to do, frankly, both they would have to do, the 24/7 and the ignition interlock, in order to be able to drive where they need to, when they need to. None of us have that predictability of when our kids are going to need to go somewhere or anything like that. And so, no, but we know of counties that are interested in this program. I've just been telling them, hold off, let's see if we can't get it changed to a privilege and now make it easier for these folks to comply. You know, the bottom line is, hey, we don't want to ruin your life. You can keep your job, just prove that you're clean and sober every day. That's all.
Thank you. Do we have any other questions from the committee members? Seeing none, I'll ask you to step back and we will start with testimony in support of Senate Bill 416. I don't see anyone coming to the table here in Carson City or in Las Vegas. So we'll go to the phone lines. Is there anyone on the phones in support of Senate Bill 416?
To testify in support on Senate Bill 416, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in support at this time.
And while we're on the phone lines, we will move to opposition testimony. Is there anyone on the phone lines to testify in opposition to Senate Bill 416?
If you'd like to testify in opposition, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in opposition at this time.
Perfect. And we will go to in-person opposition testimony. Anyone to testify in opposition, please come up to the table. Seeing no one here in Carson City or in Las Vegas, we can go to neutral testimony. Is there anyone to testify in neutral?
Good afternoon, Chair and committee members. Sean Sever from the Nevada DMV. We are neutral on SB 416, and we do have a fiscal note on it that we will be submitting shortly. Contract programming will be required over 1,000 hours to allow the 24/7 privilege to be assigned to qualified persons instead of a restricted license. As you know, the DMV is working with two IT systems now, and we'd really like to not have to program this into our old COBOL system, which is held together with spiderweb and duct tape. If the bill implementation date is pushed out to when the DMV determines sufficient resources are in place, I can get you the exact language. The fiscal impact would be severely lessened, if not eliminated. We're happy to work with the bill sponsors on an amendment. Thanks.
Thank you. I'd encourage you to reach out to those bill presenters to see if there's some amendments that might be able to alleviate some of that cost. With that, do we have anyone on the phone lines in neutral?
To testify in neutral, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in neutral at this time.
Wonderful. We will go ahead and close testimony in neutral. And do you have any? They're waving it on. So at this time, I will close the hearing on Senate Bill 416. And thank you for your presentation. And we will move next to Senator Scheibel. Is she still here in the room? Yeah. Ah, look at that, in the middle. Any preference in order?
Surprise me.
Oh, okay. Let's start with Senate Bill 194.
Thank you, Chair Nguyen and members of the committee. My name is Soraya Bonner, Soraiabohner, and I'm Senator Scheibel's intern. Today I'll do the opening remarks for SB 194. As amended, Senate Bill 194 now addresses a loophole in current laws that allows some individuals to use rental cars as a substitute for personal vehicle ownership without maintaining their own insurance. This amendment requires all renters to show proof of personal automobile insurance, promoting responsible vehicle use and protecting rental companies from undue financial risk. To speak further on this issue, I'd like to introduce Brian Quist from Budget Car Rental.
Senators, hi. My name is Brent Quist. I'm General Counsel for Malco Enterprises of Nevada, which does business as Budget Car and Truck Rental of Las Vegas. For simplicity, I'll refer to us as Malco. Malco is a franchisee of Avis Budget Group. It's a family business. John Mallow started it back in 1989. His son, Tom Mallow, is now the president and CEO, and Tom and his family reside in Las Vegas. Nevada public policy supports that every driver on Nevada roadways have personal automobile insurance. But there's one notable exception to this public policy. Nevada law does not require renters of vehicles to have personal liability insurance. As a result, Nevadans are using rental cars as a substitute for personal vehicles and thus transforming Nevada rental car agencies into de facto insurance companies. However, car rental agencies are not insurance companies. This was noted by the Nevada Supreme Court 25 years ago in a case entitled Alamo Rent-A-Car versus State Farm. There, the court indicated, quote, a car rental agency is not in the business of underwriting insurance for individual drivers. The nature of a car rental agency's business, renting cars to strangers for short periods of time, is not conducive to finding that it is in the insurance business. It does not conduct histories of drivers and does not collect a premium. Senate Bill 194 amends NRS 482.31565, which currently prevents car rental companies from requiring renters to purchase automobile insurance to rent vehicles. First, it requires the renters to provide proof of applicable personal automobile insurance that meets or exceeds Nevada's minimum automobile insurance requirements to rent a vehicle. And this can be satisfied through the renter's personal automobile insurance, what is known as spot insurance, which is short-term insurance a renter can purchase through a third party. Finally, most car rental companies typically offer supplemental insurance, which is known as renter's liability insurance. The proposed bill expressly provides that a car rental company's permitted to not rent a vehicle to an individual who does not have personal insurance that satisfies these minimum statutory requirements. If, however, a rental car company chooses to rent a vehicle to an uninsured driver and the renter is involved in an accident, the car rental agency is still required to compensate the injured person up to the statutory minimums, which is the current law. Real quick, this law is good for Nevada for at least 3 reasons. First, the correct parties will be responsible for accidents. Currently, car rental companies are financially responsible for the cars they lease to renters. Nevada law requires car rental companies to demonstrate to the DMV their financial ability to respond to damages by providing evidence of insurance. Usually this is done in the form of a certificate of self-insurance issued by the DMV. Additionally, as I just indicated, if a person's injured and they make a claim against the renter and the renter does not have their own insurance, the car rental companies are required to indemnify the renter up to the statutory minimums. And even if the renter has their own personal insurance and the claim exceeds that statutory minimum, then the rental car companies are secondary. That's not going to change. Senate Bill 194 will lead to safer Nevada roadways. Because car rental companies are not underwriters, they do not assess the safety risk, and they can't do that as an insurance company can. So if a person who operates vehicles on Nevada roadways have their own automobile insurance, that would indicate an insurance company has determined they're not a high risk. Finally, Malco considers itself an essential public service to the community. Malco and other Nevada car rental companies were kept open during COVID because our citizens needed convenient transportation, and Malco wants to continue to serve the community. However, there's economic consequences that car rental companies face due to renters not being required to have their own personal automobile insurance to rent vehicles. And this law is designed to address that. Thank you for your consideration, and we urge you to support Senate Bill 194.
Are you ready for questions? I just want to clarify, there was an amendment that was posted this morning or late this morning with a proposed conceptual amendment. I'm assuming that is favorable. And essentially, this is kind of a gut and replace. Is that correct?
Melanie
Yeah.
Scheibels, Senate District 9 for the record, yes, that is correct.
Based on this complete change, I did pass out a copy of the conceptual amendment, getting rid of the other language and adding this language. Do we have any questions from committee members? Thank you for working on this. I know that you had asked for it to be pulled so you could continue to work on it, and sometimes that leads to better, different outcomes. So I don't know. I think Senator Buck has a question.
I'm not too familiar with the industry, but I was wondering, how do you prove that somebody has insurance now? Like when I go up, I just tell them I don't want the additional coverage. I'll just use mine. How do you prove that as a budget enterprise?
Brent Quist, General Counsel for Malco. Currently, and the law contemplates that the counter agent would ask the renter for their insurance card. And it would be up to the car rental company to look at that card and make sure it's valid and that it's not expired. And that's currently that's what we would do. I also am aware if there's some technology, but I'm not able to speak on it, where, because I learned about it this morning briefly, that car rental companies have a computer program they can go in and check to see if a driver actually has insurance.
Melanie Scheibel for the record, if I could just clarify, this would also allow drivers to purchase insurance at the counter from the company, or if they're, really savvy and want to save a couple bucks, there actually are short-term liability insurance policies that you can purchase, in anticipation of a vacation, and then they could bring in proof of that. So we're not requiring people to have ongoing insurance all the time in order to rent a car, but really it's more the choice between either have your own insurance or pay for the insurance when you rent the car.
Yeah, I mean, I like the idea, I like the bill. I've just never had that happen where I've had to show my insurance card because I'm in my car at home. So, thank you.
Just to clarify, I know that every time I've rented a car, they ask me who my insurance is. They don't require my car, but they ask me who the company is. And then it's like inputted in there. But when you're signing rental car documents, you're attesting that the insurance information that you provided at the counter is correct. Is that correct? Is that a correct understanding?
Melanie Scheibel, Senate District 9 for the record. That is correct, but that's a function of the contract that you're signing. There's nothing in Nevada law that, requires a renter to attest truthfully to whether or not they have car insurance. So this would add that, statutory protection for everybody.
Perfect. I don't think we have any other questions. So with that, I will ask you to step back. And if we have anyone to testify in support of Senate Bill 194, I'd ask you to come up to the table now. And if you are in Las Vegas, please come to the table as well.
Good afternoon, Madam Chair, members of the committee. For the record, my name is Andrew McKay. I'm the Executive Director of the Nevada Franchise Auto Dealers Association. I learned about the amendment because I saw it posted on Nellis, discussed extensively the previous version, which I know that's not what we're considered, but I do want to put it on the record that we're in full support of that measure, as well as the amended version. As the senator, and I cannot remember that gentleman's name, he was quite articulate, pointed out, the cost of insurance in this state is exceedingly high, and the overall cost of ownership of a vehicle is exceedingly high. And quite honestly, I think this is going to be another arrow in the quiver to help drive those costs down. This does impact us on several fronts. We will rent vehicles on behalf of our customers when it's out for an extended period of time for a repair, or oftentimes many of our dealers are short-term lessor of vehicles. So this is another tool to protect, frankly, the traveling public across the entire state from being victims of uninsured motorists. So we fully support the bill and thank the senator for bringing it forward.
Thank you. I don't see anyone else coming to the table here in support or in Las Vegas. If we can go to the phone lines for testimony in support of Senate Bill 194.
If you'd like to testify in support, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in support at this time.
Thank you. Are there any callers in opposition to Senate Bill 194 as amended on the phone?
To testify in opposition, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. If we can go here in person in Carson City and in Las Vegas, if you are here to testify in opposition to Senate Bill 194, please come up to the table. Seeing no one, I will move to neutral testimony. Is there anyone to testify in neutral here in Carson City? Go ahead and begin when you're ready.
Good afternoon, Chair, members of the committee. For the record, it's Michael Alonso here on behalf of Turo, which is a peer-to-peer car-sharing platform. And Turo is neutral on the bill. I want to thank Senator Scheibel for allowing me to spend some time with her to talk about proposed changes. we don't have an issue really with the bill and understand what it's trying to do in terms of the insurance. In 2019, when the Peer-to-Peer Car Sharing Act was passed by this legislative body, they required the platform and/or the shared vehicle driver to carry 2 times the state minimums. And so we think from a public policy standpoint, consumer protection and parity standpoint, that the legislature should consider doing that for rental car companies as well, because that's what they have right now is if the person doesn't have insurance, it's just the state minimums. And we think it would be a good change to require the same as the peer-to-peer car sharing, since they're very similar industries. Thank you.
Thank you. And I don't see anyone else coming in to testify in neutral, and I don't see anyone in Las Vegas. So if we can go to the phone lines for any neutral testimony.
If you'd like to testify in neutral, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in neutral at this time.
Thank you. Do you have any final statements? Nope, it sounds like none. So at this time, I will close the hearing on Senate Bill 194, and I will open the hearing on, what are your other two?
359.
We'll go to 359. We'll stay in the car area. How about that? So at this time, we'll open the hearing on Senate Bill 359. Welcome back, Senator Scheibel, to go ahead and present when you're ready.
Thank you so much, Chair Wynn and members of the committee. My name is still Melanie Scheibel, and for now, I'm still the senator from District 9 in Southwest Las Vegas, and I'm happy to be here today presenting Senate Bill 359. This is one of those interesting bills, which is actually a Senate Judiciary Committee bill that was referred to your committee, and so I am, proud to be the chair of that committee and able to present to you today SB 359, which makes changes to traffic offenses. And as I'm sure, as you all know better than anybody, in recent years, Nevada's made significant efforts to decriminalize minor traffic offenses, and we treat many of them now as civil infractions rather than criminal misdemeanors. It reflects a broader understanding that not all traffic violations should carry the weight and consequences of a criminal record. However, since these reforms have been implemented, some, shall we say, inconsistencies and barriers have emerged to how civil infractions are handled in our courts. And I think there are few people better suited to speak to those challenges and those barriers than myself as a practitioner in the Las Vegas Justice Court, municipal courts, and the 8th Judicial District Court, where luckily I've not yet had to litigate a traffic ticket, but it has come close because we are struggling to figure out exactly how to implement the goals of the legislature that have been made clear time and time again through bills in the 2021 and 2023 session. So, excuse me. I'll just kind of go issue by issue, walking through. Let me pull up the bill as I walk you through it. So, I'll start with Section 1 of the bill, which pertains to civil infraction hearings. So right now, the way that the law is written, an individual who wishes to contest a civil infraction citation must first post a bond equal to the full amount of the potential penalties, fees, and assessments specified in the citation. For many Nevadans, especially those with limited financial means, this upfront payment creates a financial barrier to their right to a hearing. So many people choose not to challenge the citation, even if they have valid grounds to do so, simply because they cannot afford the bond, or it doesn't make any sense to post the bond and take the time off of work to come in and contest the citation if they're going to be charged the same amount anyway for simply paying the citation and not having to take the time off work to come in and contest it. So what SB 359 does is to change that language to say that the bond can be up to the amount of the full civil infraction. And it allows the courts to utilize their discretion to implement a bond that is less than the full amount of the citation. Further, if a person requests a hearing to contest a civil infraction citation, SB 359 permits that individual's legal counsel to appear at the hearing on his or her behalf and clarifies that if counsel is present, the person cited does not have to be present. This is, in practice, what is generally accepted in most of the courts where I practice, because there are other rules in both the traffic portion of the Nevada revised statutes, as well as the trial portion of the Nevada revised statutes, as well as our civil procedure administrative codes and the 8th Judicial District Court rules and the Justice Court rules. There are a lot of ways to get around this to allow an attorney to appear, but it's much simpler to put that in the statute where the hearings are laid out to make it clear that an attorney can appear on behalf of their client in these contested civil infraction hearings. Senate Bill 359 also brings clarity to the adjudication process by requiring that when civil infraction and misdemeanor stem from the same incident, they must be filed together in a single complaint. An example of this would be a driver who's pulled over for failing to signal a lane change. That would be a civil infraction. But if during the stop, the officer discovers that the driver's license is also suspended, that would be a misdemeanor. So instead of allowing the civil infraction and the misdemeanor citations to be filed separately, SB 359 would require that they are included in the same criminal complaint. This prevents confusion and duplicative filings while ensuring that all of the charges arising from a single traffic stop are handled consistently. Put another way, it ensures that all of the charges are put before the same judge at the same time, so that you don't have issues where, and this is what actually happens in practice, is that my clients might get those two different infractions. And so one of them, the civil infraction, might be scheduled for June 15th, and then you have the criminal infraction that's scheduled for May 15th. And when they go to the hearing on the criminal infraction on May 15th, the first thing the judge asks is what's happening with the civil infraction. And of course, we say, we don't know yet because it's coming up in June. And then we say, can we dismiss the civil infraction as a part of the deal in the criminal case? And the judge says, well, that would be great if it were in front of me, but since these have been divided into two separate cases, that has been assigned to a completely separate department. And so this would prevent that inefficiency from occurring and ensure that one judge would be looking at the complete complaint to be making adjudicatory decisions. The bill also expands the procedural protections by applying certain rules of evidence from the Nevada Administrative Procedure Act to civil infraction cases. By adopting the same evidentiary rules used in administrative hearings throughout Nevada, SB 359 provides a clear, uniform framework for how evidence is presented, challenged, and considered. Finally, SB 359 eliminates the requirement that prosecutors must elect to treat a misdemeanor traffic offense as a civil infraction before the defendant's first court appearance, and instead allows them to elect at any time to treat a misdemeanor infraction as a civil infraction during the course of the case. By removing this requirement, prosecutors will have greater flexibility, and it will allow for essentially what everybody has been clamoring for down in Southern Nevada, which is, can I please get my misdemeanor converted to a civil infraction? And I think those were a little bit out of order. I apologize. I just realized that my remarks were not in order. They were in order of importance, not in order of the bill. But I'd be happy to answer any questions.
Obviously, it's like I have PTSD every time I see this, but I appreciate you and the interim committee taking up some of the issues. I have repeatedly said that I am sure that during the course of how long I'm able to be in this legislative body, I'm sure I will be seeing this bill in some iteration come up over and over and over again. Prior to the decriminalization of these minor traffic offenses, when something was criminal and you wanted to contest or have a trial for your criminal-like citation, so let's say you had a failure to use turn signal, and that is no longer a criminal citation, but when it was criminal, if you wanted to challenge that, you didn't have to post a bond. Is that correct?
Melanie Scheibel, Senate District 9, that is correct.
But in addition to when we reduced that similar charge to a civil infraction, not only did the standard of proof go from beyond a reasonable doubt, it went down to a preponderance of the evidence. So it's a lower standard for conviction. We allowed for a lot of accommodations for affidavits, so we didn't have to take police officers off the road, and we could still get, I guess, that civil conviction. Is there any other area of civil law where a defendant in a civil action has to post any type of bond to request a trial?
Not that I'm aware of.
So the fact that there is currently in law, like the requirement for a bond for a trial to contest a civil infraction, that doesn't exist in anywhere else in any kind of civil infraction. If you are challenging, I guess, any, like in a small claims action, if you were a defendant, you don't have to post a bond to contest that.
Melanie Scheibel, Senate District 9, correct.
I know that we've had opposition, and maybe this is for anyone coming in opposition from the courts to explain why there is a difference between this type of civil litigation and the protections that defendants in this type of civil litigation receive as opposed to any other civil case. I think that's a question I'd probably be asking, so if anyone has the answers to that, I think that would be helpful. I see that there's some proposed amendments from the Nevada Judges of Limited Jurisdiction. Have you had an opportunity to speak with them? Are those friendly at this point, or are you still reviewing those?
Melanie Scheibel, Senate District 9, for the record. I have had a chance to talk to them. I have reviewed them. Some of them are friendly and some of them are not. And if you want, I'd be happy to explain the ones that are friendly and the ones that we're still talking about.
I think that would be very helpful if you wouldn't mind, and you're prepared to do that this afternoon. Do you need a copy of it?
Nope, I'm looking at it right now. So in section 1, that we are still reviewing. That language is substantially similar to language that is already contained in the bill borrowed from the Administrative Procedures Act, but I would need to review this along with the other stakeholders a little bit more carefully before making a statement either way on section 1. Amendment number 2 is not friendly. It just undoes a major portion of the bill. Amendment number 3, I guess that one I would also have to review a little bit more closely before making a determination. Amendment number 4, I believe would be fine. I don't see any issue, based on the conversations I've had with stakeholders. And I also want to note that I also received this amendment this morning. So these are like my educated guesses based on the discussion I've had before. I think amendment number 4 would be completely fine. And same with amendment number 5. If we are going to keep the cash bond in statute, then I don't foresee any issue with kind of changing the phrasing of it. As it does in amendment number 5. Amendment number 6, I also would need to discuss a little bit further with the stakeholders. Amendment number 7. Would not be accepted because the issue with the language that we're striking in section number 5 is that's what is preventing prosecutors from doing what we normally refer to as a drop down, or just allowing them to change a misdemeanor charge to a civil infraction. And so by not striking that language, we end up in the same problematic position that we're in now, where once something has been filed as a criminal citation, the prosecutor arguably no longer has the power to reduce it to a civil infraction, even though they would have had the power to charge it as a civil infraction in the first place. And just to kind of give a little bit more context to that, it's kind of like suggesting that once I file, a theft case as a felony, if I'm the prosecutor, saying that, oh, now that it's been filed as a felony, you can't negotiate that down to a misdemeanor because it was already filed as a felony. But we all know that that happens every day in Nevada courts, that something is filed as a felony and the purpose of the negotiations is to reduce it to a gross misdemeanor or a misdemeanor. But prosecutors right now are insisting to the court that they do not have the authority to change those charges from misdemeanors to civil infractions. So it's important that we make that clear.
Can I just interrupt you?
Yes,
Right
please.
now, under the existing law, they can take it from a civil infraction They can take it from a criminal to a civil, or they can't go vice versa.
So the issue that we're encountering is prosecutors interpreting the current language of NRS 484A.7049 to mean that in order to change the charge, if I'm charged in case 1234A with, misdemeanor driving on a suspended license, they're interpreting it to mean that they cannot change the charge in case 123456A. They would have to drop case 123456A and file a new civil infraction case in order to effectuate the goal of reducing the charges, which of course is a hassle, it's a burden. And if you're in a jurisdiction where the prosecuting agency has also decided that they don't participate in the prosecution of civil infractions, it puts the prosecutors in court in a very difficult position to amend their charges, to withdraw the charges that are already filed and file a new case of the type that their office supposedly does not handle.
Thank you. Sorry to interrupt. You can
No
go back
problem.
to going through the proposed amendments
And going
as you feel comfortable again.
Yeah, absolutely. Amendment number 8, I think, would be acceptable to all of the stakeholders that I've been working with. I don't see why it wouldn't be, but again, always have to check. Amendment number 9, I'm really not sure about, to be frank. We have a lot of issues with addressing juvenile traffic tickets. SB 359 intentionally excluded anything about juveniles. So I'll leave it at that. And amendment number 10, I would also I think would be acceptable. So that's where we are on the amendments from the judges of limited jurisdiction.
Thank you. I appreciate you going through those kind of on the fly. I know that this was presented, to the committee early this morning. So I know you haven't had a full opportunity to kind of go back with stakeholders, but I appreciate your expertise in this area because it probably makes it a little bit easier to review those on the fly. Do we have any other questions from committee members? Seeing none, I will ask you to step back, and at this time, if we can have people come and testify in support of Senate Bill 359, I'd ask you to come to the table.
Thank you, Chair and committee members. My name is Nick Shepek, Nickshepak. I am the Nevada State Director of the Fines and Fees Justice Center. I am also someone who is haunted daily by the bond. I think that this bill takes a really important step towards removing that bond. At the very least, it'll allow good actors to ensure that the bonds are set at a reasonable standard in which people can access the court if they believe they are not guilty of the ticket. Again, of course, as for every session, we would also support a bill to completely remove the bond. But any work we can do in this area is greatly appreciated. The rest of the fixes to the traffic system are also very needed. This has been a work in progress since we decriminalized traffic, and we are going to need to continue to make these minor changes to get the system working. We support this legislation, including with the amendments that she accepted.
If you're willing to accept a question, Senator Hansen, go ahead.
Well, even if you're not, you're stuck, man, so. Didn't we have the same bill I remember you and I talking about it at length about getting rid of the whole bonding concept, and I swear it passed, but what happened?
Thank you, Senator. If you will remember a late night at the legislature out by the front table in the foyer when we actually passed the last version of this bill towards one of the final days, we did remove that provision for the bond. However, it was a much more robust bill. I'd have to go back and read the veto message, but for some reason, it was indeed vetoed. But yes, you and I worked on that closely together last session.
All right, very good. Thanks.
Maybe it was the prosecutorial immunity that was included. Do we have anyone else to testify in support of Senate Bill 359? Seeing none here in Carson City or in Las Vegas, if we can go to the phone lines, is there anyone to testify in support of this bill?
To testify in support, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in support at this time.
$3.59.
My apologies, Chair. Can you repeat that one more time? It seems like your mic went out for a second.
Oh, I'm sorry about that. Do we have anyone on the phone lines to testify in opposition to Senate Bill 359?
Okay, thank you so much, Chair. If you'd like to testify in opposition, please press star 9 on your phone to take your place in the queue. There are no callers in opposition at this time.
We will go here in person. If there's anyone to testify in opposition to Senate Bill 359, please come up to the table and begin when you're ready.
Thank you, Chair Wynn, members of the committee. My name is John Jones here on behalf of the Nevada District Attorneys Association. We are in opposition to SB 359 as currently drafted. We have had conversations with Senator Scheibel, and we do pledge to continue working. I do agree with a lot of what she testified or presented about today. I do think there are issues that we can fix. One of the concerns that we have is, she mentioned the language requiring a civil infraction to be in the same complaint as a misdemeanor. When we passed civil traffic back in 2021, I believe, Chair, one of the major aspects for us was the fact that a prosecutor could determine for themselves whether or not they're going to handle these in court, or whether or not the officer would show up basically by themselves. This would essentially get our offices back into civil traffic, which we are opposed to. I'll point out that a lot of the states that we mirrored this after do not require prosecutors to be in the courtroom. Judges are perfectly capable of handling these minor traffic offenses by themselves without state representation. And our concern is the way this is currently drafted, it could get us back in. With that, Chair, I'm happy to answer any questions.
Do you not want the flexibility of having the ability to go back and forth? Because right now you do have the option to charge those as criminal and then amend them.
John Jones, on behalf of the Nevada District Attorneys Association, yes, I think more flexibility, we would absolutely support that. The way I read this, though, is it would require us in certain instances, and that's our issue. But as I said, we're happy to work with Chair Scheibel on an amendment.
Thank you, Chair, members of the committee. Mike Cathcart, representing the City of Henderson. I just want to thank Chair Scheibel for the time she took to spend with us. We did send some recommendations late last week, and we'll be continuing to follow up and have some discussions with her about whether we could get those clarifications and a few technical changes into the bill. Thank you.
Seeing no one else here in Carson City to testify in opposition and no one in Las Vegas, and we had no one on the phone lines, I will now go to neutral testimony. Is there anyone here to testify in neutral?
Good afternoon, Chair Wynn. My name is Kevin Higgins. I'm the Chief Judge of the Sparks Justice Court, and I'm appearing on behalf of the Nevada Judges of Limited Jurisdiction. Sitting here today, I had a bit of a flashback. In a prior life, did legislative work for the Attorney General's office. I used to sit here while Senator Raggio stared at me and asked me why we wanted one more dollar in line 397 of our appropriation bill. So you seem to be a much friendlier committee today. The judges, we've proffered that set of amendments that we talked about. You've already discussed today. I'd like to just briefly go through the amendments and explain our reasons for them. The first amendment as to kind of cleans up some of the procedural work. We're asking that a party, if they want to have a subpoena issued, they have to go through the court to get the subpoena issued. Otherwise, they can print a subpoena at home and mail it to the officer, and the court's not going to know who's been subpoenaed, and it really is a procedural problem if people are flooding the system with subpoenas, at least if it comes through the court. We're also asking that if an interpreter is requested, we get 15 days notice, and an interpreter that's to the satisfaction of the courts. I can't even imagine the languages that are heard at the Las Vegas Justice Court, but in Sparks, we lately have had various Micronesian languages, Indian, continental languages. If you walk in the door and say, I need a Chuk interpreter, which we have to find, and we've actually found a Chuk interpreter, it's problematical. It would give us notice. And we're asking in that same amendment that rather than adopting the Administrative Procedure Act, that we use the civil rules of traffic management that were adopted by the Supreme Court in an ADKT proceeding. There's actually a set of rules now the Supreme Court requires all the courts to use when hearing civil infractions. We think that just cleans it up. I understand this is open to discussion, and we'll be discussing it in further detail. Probably one of the more problematic.
Would you be open to answering some questions that we
Absolutely.
have?
I'm sorry, I tend to talk fast.
No, that's okay, just so we don't get lost on there. When we're talking about that section 1 proposed amendment, do you have a process right now for, like, I guess, people without an attorney of record or the judge to be able to issue subpoenas?
If you're a small claimant and come to the counter and you want to issue a subpoena in a small claims action, our clerk can issue one, but then it goes in the file, it's in the docket, we keep track of it, and we know that you're asking, the police department for your records, and then we can keep track of it. So there is a process.
So all of the courts have a process for that right now?
I would hope so, yes.
And then my second thing is, I've had the opportunity to review the ADKT 620, which is the Justice and Municipal Court Rules for Civil Traffic Infractions. And if it is not a part of the exhibits in Nellis, I will ask my staff to go ahead and add that in there. I realize that there are certain traffic rules that are in there. Are those similar, or are they different than typical civil practice rules for like a small claims action?
Well, this is probably closer to a small claims action than anything, but as you've commented on, this has been a moving target for a couple of sessions now. A lot of our courts are struggling to keep up with what a civil infraction is, who appears, who testifies. And so the Supreme Court kind of codified that process in the ADKT. I think it covers some of the issues that Senator Scheibel wanted to have covered in her bill. But it requires remote appearances, what happens if there's a default, what happens with appeals, and really gives a form response to a civil infraction. So I think there's a place to go rather than adopting the Administrative Procedure Act. Amendment 2 is the one that's probably problematical for us, that requiring both the civil infraction and the criminal infraction to be in the same complaint. It's kind of mixing apples and oranges, two separate sets of rules. One's criminal, one's civil. The notice provisions for the civil infractions are very different than criminal infractions. Our practice in Sparks is just to schedule them the same day in front of the same judge. And if that would be a way to fix this, just to say that civil and criminal infractions will be scheduled to be heard the same day, we'll have to coordinate that. And I commonly see people on both and hear both at the exact same time. So maybe in Las Vegas, the volume, I know I feel sorry for my colleagues there, the volume of tickets they have might be the way to handle it. With us, though, I think it would require us to reprogram our case management system, and half is criminal, half is civil, which notice goes out to who on what date. I think we could work on this and maybe get to where the sponsor would like to go, but requiring they both be in the same complaint is going to be not easy for us to do. Amendment 3, we were just trying to coordinate that with the last amendment, and making sure that the DUI, if there's a DUI, that the other civil infractions will be heard at the same time. Amendment 4 indicates that they can be dismissed on failure to comply. I don't think I'm spilling any beans here, but frankly, I'd say 90% plus of any civil infraction hearings are dismissed by default. Either the officer doesn't appear, or there's no statement from the officer made that's on the record. When we get a civil infraction, we've got notification contact points for every law enforcement agency in Northern Nevada, and we say, Trooper Smith, you have an infraction on May 1st. Please submit your statement, which will be considered in lieu of your appearance. And the vast majority of the time, we don't get anything from the law enforcement officer.
So can I just stop you right there?
Yes.
So right now, you're saying that law enforcement is issuing traffic citations, but they're not even, we knew that there was a problem with them not coming to court. And so part of the ease in trying to get these convictions and potentially ultimately points that are reported to the DMV, as we've heard, we have like a point reporting problem here in our state. They're not even doing the affidavit.
No, the majority of them, I don't know.
But the only way you would ever know that for a dismissal is if someone posted a trial bond and actually
I'll get to that in
contested
a minute,
their
but yes, if somebody asks for a hearing,
Okay.
we commonly waive the bonds if somebody can't afford it, but
But you have a ton of tickets that people can't afford to fight the ticket or don't want to take time out of their day to come in. But if they had, the ticket would likely be dismissed because there's no police officer.
right.
Okay.
And so that section 4 further allows dismissals if the other requirements aren't met. I don't want to speak out of turn for law enforcement. I suppose based upon how many officers are on the road and the time they have, they take the criminal infractions more seriously than the civil infractions. But that would be my supposition. I couldn't tell you that's absolutely true.
Well, I can tell you from the legislative history, part of the reason that we put in the affidavit requirement is because police officers weren't showing up. And this was an attempt to make sure that they stayed on the road, but we were still getting, I guess, civil infraction, like, not convictions, but we were able to do that. So it's slightly disappointing that they're not even filling out the form either, but
And
go
Chair Wynn,
ahead.
as a practical matter, the affidavit isn't always that helpful, because if the officer doesn't show up and, somebody switched a lane without a signal, and that's what my affidavit says, and the defendant shows up and says, well, that's not what happened at all. Let me tell you what happened. And I got cut off by this truck, and I had to slam on my brakes, and I had to brake and go around it. I prevented an accident. Well, there's no officer there to say, there's no witness on the other side. All you have is a flat affidavit. There's no way to cross-examine that affidavit.
But the standard of proof is a lot lower for the
That's
judges in that
absolutely right.
circumstance,
Absolutely
right?
Right.
Okay.
But if okay.
Sorry, I'm going down a wormhole. I'll let you just keep going on.
Amendment 5, we're more than happy to fix the language on what the cash bond says. Right now, a problem is a bond is a technical term. We accept cash. We would like it just to say cash or bond, and an amount up to. I think some courts have interpreted that to mean you have to file the entire thing. Our court commonly lowers the bond. We have a form to fill out that says if you want to go forward without posting the bond. I do that all the time, to waive the bond so somebody can come to court and have a witness appear if necessary.
But that isn't a part of the Supreme Court guidance. Is that correct?
Not that I'm aware of,
Okay.
no.
I just
mean,
reviewed it.
some of
I
the
don't see it in there. I was wondering if it was ever considered when promulgating like those rules for the courts across the state to consider that.
I wasn't part of that process. I
Okay.
couldn't tell you how that happened. Okay. Amendment 6 on who appears at the hearing. There's some difficulty, and as we heard from the DA's Association, we don't have a prosecutor appear. And some courts have problems with that, saying, if there's nobody here to represent the state of Nevada, why isn't every case a default? We don't let anybody else, we don't let the state go forward in any other case where they don't have to appear. So that would say that it may represent the state if they choose to do so. And I think that's under review. The problem with striking the language, Amendment 7 would leave how things go back and forth between criminal and civil, would leave it the same as they are now. I mean, I don't have any problem with cases being reduced to civil, but then I don't know who appears in court to handle it, and our DA has chosen not to appear on civil infractions, so it's just me, maybe an affidavit, and the defendant generally. Amendment 8 talks about, it kind of cleans up the language about where the money goes with municipal courts and justice courts to make sure it goes to the city or the county. I understand, and I've heard some of the history on juvenile tickets. It's been problematical in Nevada. In Washoe County, our district court wants all the tickets to go to the juvenile master, and that's where I think they should go. The juvenile master has a lot more leeway with a minor on how to handle a ticket than I do. I don't think I have jurisdiction over minors, and that's why we changed the TPOs here last session of the session before. If there's a minor versus minor protective order, that has to go to the family court. I understand there's a split opinion perhaps in district court in Vegas about whether they should be in the juvenile court or not, but I think that cleans it up. Maybe this is a red flag for some, I don't know, but that's the way we think we have to do it. And on the last one, it just cleans up that if it's a DUI and the DUI is charged and the civil citation goes with it, if the DUI goes away, then the civil citations go back to being civil citations as they were before. I mean, I know we're getting tight on time as far as the session goes, and we're happy to discuss this. We've had half a dozen training classes with the lower court judges, and I should say the NJLJ represents all the municipal and justice courts in Nevada. Over half of us, our members are lay judges. They're not attorneys, so it's not always easy for us to go through and parse the legislative history to determine exactly what needs to be done. And a literal reading by two people can lead to two different decisions on these facts. So we're more than happy to sit down and wait and work out the language as best we can. There was a question I think you promised you were going to ask, so I'll go ahead and answer it anyway, Chairman, about the bond. There are other civil procedures in Nevada where you do have to post a bond. If you're going to appeal a small claims conviction or a civil conviction or a small or an eviction to district court, we can require a bond to be posted. If you're appealing an eviction in my court, I can require you to post the bond in the amount of the rent you haven't paid. So there are, it's not, if we're going to call civil infractions small claims, there are places in the law where you do have to post money to move forward.
If you are in I recognize that for purposes of appeal.
Right.
After a conviction, that there are bond requirements in civil. Are there any that you're aware of where a defendant in a civil action has to to contest? Like if I was sued in small claims court by Julie here, would I have to contest that and ask for a trial? Would I have to post anything?
Generally, the plaintiff has to post a filing fee. But I've been thinking through my head otherwise. Of course, we took these, if it was a criminal action, of course, absolutely not. You don't have to post money to defend it, but it's no longer a criminal action. It's a civil action. And I think part of the thought process was there's a genuine likelihood, unless we collect something up front, we're never going to see anything as far as a penalty goes. There would be no reason, if there was no requirement to post a bail, then I don't know why people would even bother to contest these. Enforcement is problematical on civil infractions.
But it was problematic in criminal infractions as well.
Well, you'd have a warrant issued if you didn't take care of it sometimes, yeah, but not in the civil cases.
But in a small claims action, in other civil lawsuits, the defendant typically doesn't have to post anything.
That's true.
Thank you. Do we have any other questions? I don't see any. Thank you. I appreciate your candor, and I hope you will continue to work with Senator Scheibel to see if you can come to some agreement and some clarity. That will also help our courts of limited jurisdiction understand this legislation as we're moving forward and what our intent is going forward. Seeing that, I don't see anyone else to testify in neutral. Can we go to the phone lines to see if there's anyone else to testify in neutral?
If you would like to testify in neutral of Senate Bill 359, please press *9 to take your place in the queue. Here, we have no callers wishing to testify in neutral.
Thank you, and we will go to the bill sponsor. Do you have any further remarks? I think you do, so go ahead and come back up, Senator Scheibel. Begin when you're ready.
Thank you so much, Melanie Scheibel, Senate District 9. I just want to address a couple of things that we heard in opposition and neutral, and thank Judge Higgins for being here to talk to the Judges of Limited Jurisdictions Amendment. And I've had the pleasure of working with Judge Higgins before, and I do think we'll be able to come to an agreement on all of the proposed amendments. It's just like so many bills this time of year, it's a matter of time, but I think we'll be able to do that, just as soon as we can sit down and iron it out. I think one of the reasons, I'll try to be brief, but is that one of the reasons that we're not quite seeing that we're seeing a little bit of a mismatch is that I had not considered that civil traffic infractions would be analogous to a small claims case. Now that I've heard Judge Higgins say it, it absolutely makes sense, and I do see the similarities. I was thinking of a civil traffic infraction more similar to like an infraction that you would see from, all of our friends at the Department of Business and Industry. When someone at the taxi cab authority cites a taxi cab driver for not having their medallion displayed. When someone at the Cannabis Compliance Board cites a dispensary for not, putting the proper label on a cannabis product. I was thinking of how those administrative hearings are conducted and how those rules of evidence apply and the procedure that those go through. But actually, small claims may be a better analogy since they are being heard by judges in those justice courts, municipal courts, as opposed to an administrative law judge. So I'm sure that we'll be able to see eye to eye and come to a conclusion on that. And then the other thing that I wanted to address was the DA's concern. And like Judge Higgins, I have had the pleasure of working with John Jones many, many times over the years, and I think we'll be able to get somewhere. But I think the key provision here is in Section 4, which is on page 5. It's in subsection 3. This changes the wording about the presence of a prosecuting attorney, but it still does nothing to require them to be in court. I think the at his or her discretion and as applicable became confusing because applicable kind of suggested that there were other statutes or other rules that would dictate when a prosecuting attorney would or would not be in the courtroom. And the other reason for the change from a city attorney or district attorney may appear to a prosecuting attorney may represent the plaintiff is to suggest that we could develop a different type of prosecuting attorney. It could be an attorney who is solely charged with handling traffic infractions. And I think in other states, that is what we see. There are definitely other states that have civil infractions where the district attorney doesn't get involved. I'm not sure how many of those states have nobody involved from the prosecuting side. I think it's just simply a different agency that is involved. And so happy to answer additional questions, but I also know the hour is getting late.
Thank you. I don't think we have any other questions, but thank you for that. And I look forward to seeing what you're able to work on. And with that, we will close the hearing on Senate Bill 359, and I will open the hearing on Senate Bill, your other one is 442. It is Senator Scheibel Day here for sure.
Hello again. Melanie Scheibel, Senate District 9. And once again, I will turn it over to my extremely competent, amazingly persuasive, and just brilliant intern, Soraya Bonner.
Good afternoon, Chair Nguyen and members of the committee. Once again, I am Soraya Bonner, SORAIABOHNER, and I have the privilege of being Senator Scheibel's intern. Today, I'll give a brief overview of SB 442, which requires the Public Utilities Commission of Nevada to establish certain reporting requirements. In short, this bill would require public utilities to make public reports on terminations of service. This information is crucial for determining which areas of our state are in need of assistance securing access to needed services such as gas, water, and electricity. Utility services are necessary for life, and reports on service termination would provide information on how to best serve communities through resource access. I will now turn it over to Olivia Tanager, Director of the Toyabe chapter of the Sierra Club. Thank you.
Thank you so much. My name is Olivia Tanager, Director of the Sierra Club Toyabe chapter, like you just heard for the record. Thank you so much for the opportunity to present this important piece of legislation today. The bill before you, SB 442, seeks to address a growing concern, energy and security. As we continue to see rising utility costs associated with more extreme weather and an increasing number of households facing financial difficulties, it is vital that we have the data we need to understand the full scope of this issue and take informed, meaningful action. And I was asked to make clear on the record that this is geared specifically towards public energy utilities, not telecommunication companies that are also regulated by the Public Utilities Commission. Each year, thousands of families across our state experience disconnection of their utilities due to non-payment. These disconnections can have severe consequences, not only leaving individuals and families without essential services like electricity and heating, but also contributing to broader economic and social instability. However, the current reporting practices for these disconnections are insufficient. Many utilities report disconnection statistics at a broader level without breaking them down regularly by specific factors. And without the data that we're asking for with SB 442, it's difficult to understand the full extent of energy insecurity and identify targeted solutions for those most in need of support. This bill requires public utilities to publicly report the number of monthly disconnections due to non-payment. The data must be broken down by zip code, providing a more detailed understanding of which communities are most affected by disconnections. This data will be available in a publicly accessible format, allowing local governments, advocacy groups, and concerned citizens to track trends and advocate for policy changes as necessary. Okay. Ooh. There we go. Okay. So of the 50 states in Washington, D.C., 26 have at some point instituted some level of reporting on utility disconnections due to non-payment. Nevada has not. If the committee has any questions about what this legislation or regulation has looked like in other states, I'm happy to share that information with you, but for the sake of brevity in today's hearing, I will mention that it varies widely from state to state, but the bones of what is required in other states are largely found in our proposed bill here. Data aggregated by month that includes the number of disconnections and the associated zip codes. So we do have some level of information on current disconnections, and I think that the information that we do have highlights the need for better reporting. Through the Public Utilities Commission, we get reports in April on the number of disconnections per zip code in the previous year. This is the zip code that I live in, 89502, which is why I pulled it. I'm familiar with the zip code. So it's estimated across the country that 1% of households experience energy disconnections annually. Energy insecurity is also associated with forgoing other necessities such as food and medicine. As our world heats up and weather becomes more erratic, lack of electricity also increases the risk of illness and death for our most vulnerable communities. Based on the information we do have available, I calculated that the disconnections in my zip code, 89502, were at around 5% of those who live in the zip code, highlighting a significantly above average percentage of disconnections. I also pulled the zip code 89115, which is a zip code in southern Nevada that covers Sunrise Manor and the Nellis Air Force Base, just to include some disconnection information that we have in another part of the state. Again, if anyone on the committee would like information on particular zip codes and disconnections over the years, I'm happy to share the information that we do have. I did also look at some rural zip codes that NV Energy serves, and I will note that the trend of rising disconnections look different in different zip codes based on existing data, but generally the trend of rising disconnections held true. And so then here we have the total number of NV Energy disconnections. And I hate to pick on NV Energy, but it is what we have available. So when looking at this graph, which is the only publicly available information I was able to find, as an advocate for folks to keep their lights on, I have a lot of questions that are left unanswered. Now, SB 442 wouldn't necessarily help us answer all of those questions, but it might help us start asking better questions about how to collaboratively solve what is evidently a huge problem impacting folks in our state. What months did most of these disconnections occur? When do folks need information about services that exist to get assistance in keeping their lights on? How do communities in northern Nevada fare in the winter? How do communities in southern Nevada fare in the summer? How effective were federal monies and other programming designed to help weatherize homes and help folks keep their lights on? And again, which questions are we not able to ask and not able to answer because we have such limited information available? So in closing, this bill is an essential step towards building a more equitable, transparent, and compassionate approach to managing utility services. It empowers communities, protects vulnerable populations, and provides policymakers with the data they need, you all need, to act decisively to combat energy insecurity. And so really the intent of the bill is to make sure that we have regular information so that we can drive services that exist to help folks keep their lights on where they're most needed, when they're most needed. It helps decision makers respond in a timely manner to disconnections. I did want to note that as of last week, LIHEAP, which is a low-income energy assistance program that exists at the federal level, all of those folks that administer that program were unfortunately fired. And so there is some question about the longevity of LIHEAP and how that's going to impact folks. In 2023, Nevada got $29 million for LIHEAP funding. And in 2024, we got $17 million for LIHEAP funding. And I believe that goes to about 12,000 families across our state. So now with the status of LIHEAP in serious jeopardy, that's just one example of why having regular disconnection reporting would be helpful in understanding how this is going to impact families and how we can get services and information to the folks that need it the most. And again, be able to respond in a timely manner. With that, what was that?
Any amendments?
Oh, yes, thank you. You'll also note, I believe it's available on Nellis R, the amendment that was submitted this morning. So through good faith negotiations with stakeholders, we did amend the reporting to not be monthly, but to be quarterly. The data will still be aggregated by month, so we can still see the breakdown by month in which months folks are experiencing the most amount of energy insecurity. We also had a slight language tweak in how the report is made available, just making sure that the report will be public, but allowing a little bit more flexibility in how that report can come to fruition and can be made public. Thank you.
Thank you. Do we have any questions? Go ahead, Senator Hansen.
Thanks, Chair. Actually, I just saw the amendments. The question I had was the demographic part. You guys are striking that out. Okay, good. That makes, I mean, I don't know if the utility company is supposed to know what the race of the person who's buying their services. So the other question is, these are all public utilities for the most part. They always obviously want to get paid. So don't they have programs in place already to assist people who are struggling? Because obviously it's to their total advantage. I mean, the last thing they want to do is shut your power off. What they want to do is leave the power on and then get paid. And if their assistance is available through whatever programs. I mean, what I don't understand is there already is a complete motive in place for them to do everything possible to make sure that their customers are assisted because they benefit financially. What is missing in that? What problem are we trying to solve here? Because if all you're looking for is zip codes, I can tell you right now, the poorer parts of town are going to have more people getting shut off than Incline Village in Washoe County. You know what I mean? It's pretty basic economic principles. Poor people struggle more to make their bills. I don't think that's some great conspiracy on the part of the utility company. So I'm just wondering, what is the end goal? Are we trying to actually increase the number of people who can pay their bills? And if that's true, isn't that something that they would already be incentivized to do?
Thank you for the question, Senator Hansen. Olivia Tanager, for the record. So yes, we do want the utilities to be able to keep folks' lights on, and they do indeed have programs in place to help folks do just that. But especially with some of the funding in flux now, the LIHEAP that I mentioned, there will be, I anticipate there will be an increased reliance on some other monies that are available to help folks keep their lights on. Some of the examples that I've shared with folks, there are church programs that exist to help folks keep their lights on. If we knew what time of year we needed that money to be distributed, we would be better able to engage with places of faith or other charities that exist to help people keep their lights on. I've talked with somebody who plants trees. If we knew what time of year folks were being most impacted by utility shutoffs and what zip codes were being most impacted, and really the scale of the problem, right? Because that's one of the things we don't know when the scale is at the greatest, we could be able to help folks plant trees in their yards to help bring their bills down, make their homes more shady. So there are a million different examples where we could drive services that exist to the people that need it the most when they need it the most. And without the publicly available information, it makes us less responsive and less able to do it. I do agree that we can hypothesize, right, about what communities are most impacted, but we're not certain about when the disconnections are occurring exactly throughout the year and when that information would be most helpful and when the payments would be most helpful, any financial assistance that exists to help folks keep their lights on, while also making sure that the utility folks are able to make ends meet too.
Okay, I got it. But still, the most helpful programs would be beneficial to the very companies. You know, if you were struggling to pay your plumbing bill and there was some way that I could help you pay the plumbing bill that you have to me, I would be all over that. I wouldn't need any government agencies to say, hey, guess what? If you plant trees, you know, it might help your, not clog your, you know, whatever. So I'm just kind of, I'm trying to understand the real intent here. Originally, it sounded like there was an implied, perhaps, you know, racial motive, and so we're going to look at the demographic breakdown to see if minority communities are disproportionately impacted by shutting off their power, but we got rid of that, so we're kind of back to, you know, I just have a hard time seeing where anything in this is going to benefit any customers long-term, because the incentive is already there for the power company. They want to get paid, that's all. So, anyway, thanks, Madam Chair.
And if I could respond briefly, Chair, thank you. Olivia Tanager again for the record. So, you know, I pulled the information on my zip code, and like I said, we are already above average for disconnections, at least in my zip code, and I believe statewide as well compared to the national average. So I think it's pretty clear that there is an issue with folks' ability to pay their bills as it stands. And so we're just trying to make sure that we're being strategic, right, in the way that we're sending money to the folks that need it the most to help keep lights on, because we have a limited amount of services that are available, and it is currently a problem. And so I think, you know, the intention of the bill is to make sure that we're sending money where it's needed the most, when it's needed the most. Because if folks are struggling to pay their bills in July, but, you know, whatever programs exist aren't distributed until December, well, that doesn't help us very much. And so I think there's a lot of questions that we still need to answer, and I believe that SB 442, with the reporting mechanism, would help us be able to better answer those questions.
Okay, thank you. I'll be looking forward to the utility companies explaining, do you guys just ignore people when they have methods to pay their bills that you could help them out with? Anyway, thanks, Madam Chair. But I would like to answer the utility folks if they have a chance to testify later. Thank you.
I have a quick clarifying question. I know in the conversations that I've had with you all about the need for this bill, it wasn't so much like an attack on the utilities and what kind of services and what kind of things they do try to provide. In fact, you had mentioned that some organizations do really everything that they can to try to keep people in, often for years and years at a time, even though they are delinquent in some of their payment of their utility bills. I also know that like our own governor has really like purported to get behind like a no wrong door kind of thing with welfare services and in health and human services with our aging and disability communities. Is this kind of information that would help organizations within our own state make sure that we're not doing duplicative services and that we're getting to some of those communities that are maybe at risk?
Olivia Tanager for the record, yes, that's exactly right. And that's exactly why I brought this bill forward in the interim, because I was hearing from a lot of different folks who were really interested in helping folks keep their lights on, but without having an ability to understand what the scale of the problem is. And again, when the scale is at its peak, it makes it really hard for us to properly distribute services when they're needed, where they're needed.
Would this also help in obtaining grants and other, like even private grants from like our corporate, you know, philanthropy as well as any federal grants, having like this more specific data about what the need is in our community?
Olivia Tanager for the record, yes, I believe it would. I believe if there are community organizations out there who have the ability to apply for grants and then distribute money to help people keep their lights on, we are going to be able to more efficiently and more effectively distribute that money, again, when and where it's needed.
Thank you. And I think Senator Pizzina also has a comment. Oh, nope, never mind. I think it was answered. I don't see any other questions. If you don't have anything else to say, I'll ask you to step back and we'll have testimony in support of Senate Bill 442 come up to the table. And I'll just remind everyone we have one more bill, so. Me too is always acceptable.
Thank you for the opportunity to address you. My name is Leslie Vega. I work at Plan, and we are a friend to the Sierra Club, and we're so grateful that they brought this bill forward. This bill would provide something that should already be standard, and that's clear, accessible data on who is being disconnected from power and where. The absence of this information keeps communities in the dark, both literally and figuratively, while households across Nevada are forced to make impossible choices between electricity, food, and medicine. I work closely with Nevadans from all walks of life and have seen how energy insecurity shows up differently across the state. In Clark County, a utility shutoff can quickly become a medical emergency during extreme heat. In Washoe County, growing housing instability and rising temperatures make electricity more of a public health necessity than a convenience. And in Elko County, rural isolation compounds the risk when services are out of reach and residents have limited options for assistance. So I urge you to support this bill, SB 442. Thank you.
Thank you, Chair and committee members. My name is Nick Shepak, N-I-C-K-S-H-E-P-A-C-K. I'm the State Director of the Fines and Fees Justice Center. I'll be very brief. The more data points we have on economics, the better we can measure everything. I can overlay from my own work fines and fees data over shutoffs, and we can infer something. If we build a new housing project or make an investment in this body, and we can then see if there is a reduction in energy shutoffs as well as other financial data points. The more data we have, the better decisions we make, the better legislation we write. We support this. Thank you.
Ross Kinson, K-I-N-S-O-N, with the Northern Nevada Central Labor Council. From the perspective of labor, we advocate for our members and any data points that we can use to help advocate for them and possibly help them if they're in a situation where they need that help, makes it so we do our job better. So for those reasons, we support the bill. Thanks.
Thank you, Chair Wen and members of the committee. My name is Caitlin Gutchinyan, and I'm the Nevada representative for Southwest Energy Efficiency Project, or SWEEP for short. We appreciate the opportunity to submit testimony in strong support of SB 442, which would establish the mandatory disconnection reporting requirements. But essentially, we support this bill. You can read my testimony online. I'm not going to take up too much of your time. Thank you.
Hello, members of the committee. My name is Jamarion Williams. I'm the Government Affairs Manager for Western Resource Advocates. In interest of time, I'll just ditto what we heard earlier. We are a strong supporter of this bill. Thank you.
Hello, Chair Wynn, Vice Chair Pazina, and members of the committee. My name is Julia Hubbard, and I'm with Solar United Neighbors Action. As you heard earlier, we help people go solar, but we also believe in a fair energy system where consumers are educated and protected, and utilities are held accountable. We represent the needs and interests of almost 125,000 solar owners. SB 442 is about transparency. This disconnection data should be available to us so that we can use it to focus on preventative solutions, as we heard. California, North Carolina, Michigan, Illinois, Missouri, Georgia, and Hawaii all require utilities to report disconnection. Nevada should join the ranks. As an organization that believes in building an equitable energy system, we strongly support this bill and urge you to do the same. Thank you for your time.
Good afternoon, Chair and members of the committee. My name's Rob Baston, B-A-S-T-I-E-N. I'm a private citizen, and I'm here to testify on my own behalf. Energy prices are not going down, nor have food prices. The cost of living is not going down, and now it certainly appears it'll be getting much worse. As a result, people are suffering. I am fortunate that I can weather the current trend, but many people cannot. I've recently been involved with both the Nevada Energy and the Public Utilities Commission in Nevada, PUCN, usually about the request by Nevada Energy to raise customer rates. At every PUCN consumer session or hearing I've attended, there are individuals who are pleading with Nevada Energy to not increase the rates. Many of these folks have to choose between paying energy bills and cutting back on food and or medicine, or both, and many have their power cut off. Nevada Energy needs to let the PUCN know what it is doing to these Nevadans, when it is doing it, and the reason why. Not paying for electricity as a reason to disconnect service is too general and vague. There are extenuating circumstances that definitely come into play. Monthly reporting on customer disconnect service by Nevada Energy to the PUCN is a good start in addressing this problem. Maybe from this, the owner of Nevada Energy can be made aware of what his company is doing to the people of Nevada and actually become more philanthropic. I am in support of Senate Bill 442 and would like to see it pass. Thank you.
Reverend Paul Larson, Paul Larson, Director of Lutheran Engagement and Advocacy in Nevada. On behalf of Lutherans across Nevada, we support SB 442.
Thank you, Chair and members of the committee. For the record, my name is Christy Cabrera-Georgeson. I'm the Deputy Director of the Nevada Conservation League. We are here in support of SB 442. Would just like to ditto all the comments previously made. Thank you.
Good afternoon, Chair, committee members. For the record, my name is Noe Orozco. That's N-O-E, accent over the E, O-R-O-S-C-O. I'm the Government Affairs Manager with Make the Road Nevada, and we also just want to add our voice to all the support and for all the reasons that was previously mentioned. Thank you.
Thank you, Chair and members of the committee. My name is Ernest Figueroa. I'm the Nevada Consumer Advocate and the Executive Head of the Attorney General's Bureau of Consumer Protection. I hereby testify in support of this bill for all the reasons already previously stated. Thank you.
If we can go to Las Vegas, go ahead and begin when you're ready.
Good afternoon, Chair and committee members. Henry Rosas, H-E-N-R-Y, R-O-S-A-S, External Affairs Manager for United Way of Southern Nevada. And to Chair, to your point, absolutely this bill would support on the philanthropic side. Here to just share, United Way of Southern Nevada is one of the principal administrators of the Emergency Food and Shelter Program, which are federal funds that are administered by FEMA to do rental and utility assistance for communities across the country. Clark County was allocated $1.2 million for this program, but those funds have been put on an indefinite hold. And so as we, on the philanthropic side, think of fundraising to fill those gaps, and just filling in gaps with continued reductions in funding and services, having the state is actually very, very beneficial to make sure that we can meet the most immediate, urgent needs in a timely fashion. So United Way is here in support and urge the community to do so as well.
All right, hello and good afternoon, Chair and members of the committee. My name is Hector Ariola and I am the Policy Fellow with the Nevada Environmental Justice Coalition. We are a community organization-based coalition fighting for sustainability, justice, equity, and all levels of government decision-making. And together we build people power through grassroots organizing and policy advocacy. And we are here in full support of Senate Bill 442. When individuals lose access to utility services, their lives are put at serious risk. Yet without accurate and comprehensive data, we can't know who is being affected the most, nor can we take meaningful steps to address this issue. This is why accurate, transparent data collection is not just important, it is vital in making informed decisions. It allows lawmakers to understand the scope of the problem and take target action to protect our most vulnerable population. This bill is fundamentally about transparency, but most importantly, it's about helping save lives. If we fail to measure the problem, we fail to protect our community. I want to thank you for your time and your dedication to the people of our state.
Thank you. I'm seeing no one else coming to the table in support of testimony. If we can go to the phone lines for testimony in support of Senate Bill 442.
Testify in support on SB 442. Please press star 9 on your phone to take your place in the queue.
Hi, this is Carrie Rohrmeier, R-O-H-R-M-E-I-E-R, with the Nature Conservancy. We support SB 442 on the belief that tracking and reporting information about disconnections and terminations of service will help us all understand the equity impacts of unaffordable energy costs in Nevada. Thank you.
We can go to the next caller.
Caller with the last 3 digits, 552, please press star 6 to unmute yourself.
Good afternoon, Chair and committee members. My name is Mary Wagner, for the record. That is MaryWagner. And I'm speaking today on behalf of Moms Clean Air Force and Ecomadres. We are a community of parents and caregivers who believe every child deserves clean air, a safe home, and healthy future. We are in strong support of SB 442. Transparency in disconnection data is not just about numbers, it's about people. This bill will help us understand when families are most at risk of losing essential services like heat, electricity, and hot water. It would also allow our organization and others, other community groups and individuals to step in and provide support when it's needed the most. Our children should never have to worry about whether they can stay warm in the winter or take a hot shower after school. Unfortunately, in uncertain times like these, many safety net programs are being reduced or eliminated. We must do everything we can to ensure Nevada families aren't left in the dark, literally and figuratively. We urge your support for this important bill, and thank you for your time.
We can go to our next caller.
Hello, Chair and Committee. My name is Ruth Flack, and the spelling is Ruth, R-U-T-H, F as in Frank, L-A-C-K. I'm calling in support of SB 442 for all the reasons previously stated. We need accurate, real-time data reporting from Nevada Energy in order to ensure that the needs of our at-risk citizens are met, being able to pay their utility bills. Thank you.
Thank you. Do we have any other callers in support?
Yes, good afternoon, Chair and Committee. My name is Paulette Henriade. That's spelled P-A-U-L-E-T-T-E. Last name H-E-N-R-I-O-D. I'm representing Mormon Women for Ethical Government, or MWEG. MWEG is a grassroots organization that is concerned about the health and economic impacts of energy availability and affordability on individuals and families in our state, and we support SB 442. Thank you.
Good afternoon, members of the committee. My name is Audrey Peral, A-U-D-R-E-Y-P-E-R-A-L. I'm here on behalf of Chispa Nevada, a program of beleaguered conservation voters that builds the power of low-income Latina families to achieve climate justice, community health, and environmental protection. We are in strong support of SB 442. For years, our communities have spent a disproportionate share of our income on electric, gas, and water bills. And in times of economic hardship or extreme weather, a utility shutoff can be devastating, especially for families with young children, elderly residents, or those with health conditions. This kind of transparency is essential. It helps ensure that utility shutoffs are not happening without oversight and that resources can be targeted where they are needed most. SB 442 reflects a fair, data-informed approach to utility regulation that prioritizes public health, community stability, and equity. We urge support. Thank you.
Good afternoon, Lisa Ortega, O-R-T-E-G-A. Thank you, Chair, and thank you, Senate Committee on Growth and Infrastructure, for all your work. I am a master arborist in the state of Nevada and the founder of Nevada Plants. We are a statewide tree planting nonprofit. We plant trees with communities, but we also give quite a few of them away to residential. We would use this data to plant trees where possible. In these zip codes, we can do the most good. In Southern Nevada, south and west facing windows need shade, and evergreens on the north side block the winter winds in Northern Nevada. We promise to use this data to plant trees. Thank you.
C-Y-R-U-S-H-O-J-J-A-T-Y, Cyrus Hojati, and I want to call in support of this bill. I like the transparency
We appreciate the sponsor and the committee for allowing us to speak. And the last bill, previous bill was pretty good too. Thank you. Ditto. Yield.
Thank you. Do we have any other callers?
Good afternoon, Chair Nguyen and members of the community. My name is Denise Heredia, Heredia. I'm the Associate Director of Return Strong, and we fight for the rights of dignity of incarcerated people and their families, and we strongly support SB 442. As a working mother, I know what it's like to juggle bills, rent, and rising costs and still come up short. Like many families impacted by incarceration, one income often isn't enough, and many of us work multiple jobs just to get by. SB 442 brings needed transparency. It helps us understand who's being impacted and why, so we can push for real change and protect vulnerable families, and we urge your support. Thank you.
Chair, there are no more callers in support at this time.
Thank you. At this time, we will go to testimony in opposition. If you are here to testify in opposition, please come to the table and begin when you're ready.
Good afternoon, Chair Nguyen, members of the committee. For the record, my name is Nick Schneider, Director of Government Affairs for the Vegas Chamber here in soft opposition to SB 442. We did have some concerns regarding the frequency of the reporting as well as the scope of the demographic and data that was being collected. That is all being covered by the amendment, so we look forward to moving to neutral should that be adopted. Thank you.
Thank you. Do we have anyone else to testify in opposition, either here or in Las Vegas? I don't see anyone. If we can go to the phone lines for testimony in opposition of Senate Bill 442.
To testify in opposition, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in opposition at this time.
Perfect. And at this time, I will go to neutral testimony. For Senate Bill 442. You can come to the table and testify at this time in neutral.
Good afternoon, Chair Nguyen and senators of the committee. My name is Dylan Keith, Dylankeith. I'm the Senior Manager of Government Affairs for Southwest Gas. We would like to thank the senator as well as the Sierra Club for coming to the table with us and finding a neutral middle ground. At Southwest Gas, we are proud to, on average, only disconnect about 5% of the people that are eligible for disconnection, because during that time, we are walking them through steps where we can get them either on deferred payment plans, assistance from the state, or assistance from our nonprofits, which generally go through our Energy Share program, which would include Help of Southern Nevada, ULAN, as well as Friends in Service Helping or FISH in Northern Nevada. We're very proud of the robust portfolio that we have available, and we are always looking for assistance. So we're happy to partner with them, and whenever we are out in the community, we would love to see them there.
May I ask you a question, if that's okay? You had heard some of the testimony and some of my questions about whether or not this data would be helpful for nonprofit partners than the state, like you had indicated that you work with. So would providing this information further help, you think, get some of those bills paid, our assistance in some of those bills being paid where maybe you are not able to provide that assistance, which it sounds like you do in 95% of the cases?
So when folks are looking for assistance or when they are becoming close to delinquency, we are sending them mail as well as phone calls. So they are made aware of what assistance is available, and we do our best to make sure that it is available as well. We were especially sensitive to this when we were experiencing extremely high bills because of national and international events that were outside of our control. For that reason, we sent out messages to every local elected official, the caucus directors for both the Senate and Assembly, through the governor's office, and to our congressionals and senators to make sure that we were getting the word out as much as possible. We were attending senior care events at senior facilities. We were going to churches to speak to the community. There was nowhere we would not go if we were asked. We do the best we can to get the word out. Currently, I'm not quite sure how to answer that.
No, I think you did, and I think Senator Hansen also has a follow-up. And I'm sure this will apply to you, NV Energy, so when you speak, if you can answer some of those questions as well.
It'll actually be for both of you guys. Okay, right now, okay, Ira Hansen falls behind on his gas bill, and you guys are gonna shut off my gas meter. What's the time frame? Okay, I'm behind. I've been making payments, and I lose my job. I miss one 30-day window. How many opportunities do I have before you guys literally come out and lock off my meter?
So to be eligible for turn off with Southwest Gas, that would be 60 days if you owe more than $500, which is quite a substantial amount of gas. Other than that, it would be 90 days below $500. And at that point, we began reaching out to those customers and trying to figure out solutions.
Okay, well, that was my next question. Obviously, you know, if I have assistants out there that can help people pay my plumbing bills, I'm going to be quite anxious to say, hey, Catholic services are available, you know, they're Salvation Army, whatever. Don't you guys already have some PR department that would direct customers who can't pay their bill to somebody that can assist them? I mean, obviously, it's totally to your advantage. Last thing you guys want is to shut off your customers. You know, once you shut your customer off, there's no money being made for you guys, but all of the costs are still there for maintaining piping and so forth. So I'm just kind of trying to figure out, don't you already do all these sorts of things already to try to maximize the payments to you guys, to your companies? I just don't see where there's like, you're just going out locking off people like, hey, I don't give a damn if you can pay your bill or not, goodbye.
Yes, and thank you, Senator, for the question, and sorry, through you, Chair, to the Senator. Thank you. We do currently offer programs. As we looked over the last year especially, we would include it in, it's called the buck slip, where we are including that in the bill with additional information, including it across our PR agency or our PR side and through our social media programs. We are including it in emails. We wanted customers to know. We are not hiding the fact that we have that assistance available.
And a last question for you, and that is, you, by what you already said, you are collecting this data currently, right? You mentioned that only 5% of the people that are eligible to have their power disconnected actually end up being disconnected. So I know there's a mandatory quarterly report that you guys have to provide to PUC, but you guys are already analyzing these types of data on a month-by-month basis. So if in fact they did make this a requirement, what's going to change for you guys, if anything?
So thank you, Senator. For that, our billing department is currently generally overseeing that. So I had that information from our Director of Customer Technical Support. This would change it from that side of the company over to a regulatory side, more than likely, where we would also begin reporting that out. So currently, the PUCN could ask for this data. There is no, there's nothing preventing them from doing so. But as you will hear in a bill later today, we are generally trying to free up their time as much as possible to reduce any burden that the PUCN may have.
Good. Well, my question's a little premature. I apologize. I'm hoping PUC will get up in neutral, and I know NV Energy's here right now, so I look forward to hearing what you guys have to say and maybe follow up with some additional questions. Thank you.
Go ahead, Senator Buck.
Thank you so much. I was wondering about privacy requirements, or if I'm late on paying my bill a couple of months, but yet I'm going to be paying it, you know, having your information released. Is there any concerns with that?
Thank you, Senator, for the question. Yes, there is. That is one of the reasons we wanted to work with the sponsor of this legislation to tailor it down a little bit better. Our customers' data is one of the largest concerns that we have. Data security is taken very serious at Southwest Gas. It is one of the top safety concerns that we have because people are actively looking for it. So we do everything in our ability to make sure that our customers are safe and that we are trusted.
This bill as amended doesn't require you to post any names or addresses or anything of the people that they're seeking to get data on. Is that correct?
No, Madam Chair. This would include just the number of individuals that are disconnected by zip code per month.
So all that personal information is protected under the way that this is drafted and as proposed in the amendment.
Yes, Chair, and we would keep that as locked as possible.
And then just to go back on this, I know that there's some question on why this bill is needed. But you mentioned yourself a couple of organizations, including state agencies, as well as nonprofit partners like ULON that you partner with right now to help people get energy assistance in those situations where you're not able to do it internally. If they are saying that they need that kind of information in order to get grants and corporate sponsorships and other like philanthropic like donations, that would only help you all get your bills paid. Is that correct?
Thank you, Chair. Yes, it could. For the most part, our energy share programs are put forward through our actual customers. So our customers are very generous in their billing cycles. We take that money and we distribute it out to the nonprofits, which give us assistance. The additional dollars definitely wouldn't hurt. We're always happy to make sure our customers are taken care of. Beyond that, our deferred payment programs are in-house, and state program would be through a separate discretion.
Thank you. We'll go ahead and we'll get you off the hook right now for now, and we'll go. You're on the hot seat now. Go ahead.
You got to stay up here, I think, just in case. Good afternoon, I think now evening, Chair and members of the committee. My name is Anthony Ruiz, spelled R-U-I-Z, representing MV Energy. We're here testifying in a neutral capacity on Senate Bill 442 and the amendment. I'd like to start by saying we appreciate the thoughtful work of the Sierra Club and Senator Scheibel on this legislation, and that MV Energy shares the goal of ensuring that our vulnerable customers, Nevadans, have access to support they need to help keep their energy service connected. So we don't collect income data directly from customers, but we do use some current zip code analysis that we do to try to prevent and identify which customers may be vulnerable. We could see what programs they're participating already with MV Energy and other partnerships, as was mentioned by earlier with United Way. And we do that to begin to try to identify and find and support our low-income customers to better understand where we could deploy our resources that we have. So these programs like Project Reach, Project Safe, and Flex Pay, we've helped tens of thousands of customers help manage and pay their energy bills. Just the last 3 years, we provided more than $2.8 million in direct financial assistance through Project Reach and Project Safe programs alone. And then we've also proposed a new low-income rate in our upcoming general rate case for Southern Nevada that would help qualifying customers receive a full discount on their basic service charge every month in their bill. And so we just appreciate the intent of Senate Bill 442 and look forward to working with the Commission, if need be, to align any new reporting requirements with our existing capabilities and the privacy protections as well that was mentioned. So thank you. And if there are questions, I'll do my best. But my colleague has answered most of them, I think.
Go ahead, one. You could always follow up offline.
Just
you know.
one. So you gave out $2.8 million and it came right back to who?
Anthony Ruiz with MV Energy. Thank you, Senator. So these, the funds, about $1 million a year, go directly to low-income customers that are eligible. They have to be a senior citizen as well as demonstrated need of assistance on their bill. They would apply through United Way on their website to receive that assistance, and it goes to them. The funds that I mentioned, $2.8 million, are from MV Energy. And then there's some additional support that United Way has in addition to that, and they could send that data if needed.
Okay, no, my point was ultimately it's to get your bills paid, right? So you guys get the money, whether it's through United Way or whatever, you give all these assistance programs, but the assistance is to make sure their utility bills are paid, and they are paid to you guys. So, you know, it's a circular kind of a thing, which I'm fine with, I get. I mean, but that's the whole point. It's totally to your advantage to have all these programs in place, and they're already in place because you guys want to get paid. I mean, obviously you don't want to shut, you know, senior citizens' power off and so forth, but ultimately for your stockholders and just good business practice, you don't provide a service without expecting some level of payment. And for people that struggle, you also have programs in place right now to help them pay you. So I got it, and I'm fine with that, but, you know, and just Like we're acting like you guys are just running around shutting everybody's power off, when in fact, it's totally 100% to your advantage to keep everybody's power on. And if somebody else can assist them paying their bill, fine. But ultimately, that's what it boils down to. You guys are getting paid from whatever source the money is, good for you. And that's what all these assistance programs are designed to do anyway, correct?
Anthony Ruiz, MV Energy. I appreciate the point and the question and some of the comments. I think you're right in that it is to our benefit and the customer's benefit to keep them connected. There are some data that we could follow up on, and if the customer falls behind, it continues to fall behind, the greater that burden is, the more likely they are to be disconnected. And so you're right, early interventions to the customer support keeps them connected. It prevents the problem from getting larger, and that's certainly within our interest, and that's aligned with the customer's interest fully.
Okay. Thank you, Madam Chair.
Thank you. I think we're good. At this time, do we have anyone else to testify in neutral? I don't see anyone in Las Vegas. I don't see anyone here in Carson City. We can go to the phone lines for any testimony in neutral.
To testify in neutral, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in neutral at this time.
Thank you. And with that, do you have any final, go ahead, come out to the table.
Thank you, Chair and members of the committee. Olivia Tanager again for the record. I'll be super brief. As you just heard, this really is a win-win-win, right? It's a win for advocates to know where to distribute money, when to distribute money. It's a win for the utilities because we're helping folks pay their bills and keep their lights on. And certainly it's a win for service providers who want to also help folks keep their lights on at the times that they need help the most. So with that, I'll follow up with anybody who has any more questions, but I appreciate your time today. Thank you so much.
Thank you. And with that, we will close the hearing on Senate Bill 442, and I will open the hearing on Senate Bill 417. And again, I will remind everyone, you've been so patient on our hearing on 5 bills today. So again, I would encourage as much brevity in your support or opposition or neutral testimony as possible, and go ahead and begin when you're ready.
Good afternoon, Madam Chair, members of the committee. My name is Scott Leedom, SCOTTLEEDOM, Director of Regulation and Public Affairs with Southwest Gas. I'm joined today by Amy Timperley, our Senior Vice President and Chief Regulatory Officer at Southwest Gas. Thank you for the opportunity to present Senate Bill 417, which deals with alternative rate making for natural gas utilities. Alternative rate making involves adjusting traditional methods of setting rates in a number of different ways, which I will go over here shortly. And alternative rate making for utilities in Nevada was first considered by this body during the 2019 legislative session when then Senator Chris Brooks sponsored Senate Bill 300. That bill allowed only electric utilities to apply for an alternative rate making plan with the PUCN. Senate Bill 300 passed unanimously through both houses without opposition or without fiscal impacts. We present Senate Bill 417 as a near mirror to that legislation to afford natural gas utilities the same opportunity to apply for an alternative rate-making plan with the PUCN. First, I want to quickly explain what this bill does not do. This bill does not set energy policy. This bill does not expand natural gas infrastructure throughout the state. It does not contemplate the determination of a natural gas utilities investments, as that is done in our resource planning process that was established last session with Madam Chair's bill, Senate Bill 281. It also does not allow any natural gas utility to arbitrarily raise prices on its customers, as you may have read online. This bill maintains full and complete authority of the PUCN over all rates charged to utility customers. What the bill does allow is for natural gas utilities to apply to the PUCN for an alternative rate-making plan in the same way the electric utilities can. Alternative rate making creates more predictable rate changes and lowers administrative costs for the PUCN, the Bureau of Consumer Protection, our own internal resources, as well as for your constituents, and those cost savings are passed on to customers. This is important because alternative rate making has the potential to avoid future costs and gain efficiencies for us, the PUCN, and other stakeholders involved by alleviating the need for frequent general rate case filings with the PUCN. For your constituents, this would mean our price changes would potentially no longer have the cumulative stair-step increases to reflect the cost of providing service and rates. Instead, these adjustments would be smoother and incrementally smaller. This means more predictable bills for Nevadans and savings from reduced administrative costs. Our costs of providing service are separate from gas usage costs. We acquire the lowest cost gas portfolio on behalf of our customers, and the average price over the past 12 months is what we currently are allowed to recover through gas usage costs on a customer's bill. This bill will not change anything about that. Senate Bill 417 does have the potential to benefit customers by avoiding rate shocks, encouraging gradualism, and achieving a more stable rate-making process that makes prices more predictable. It gives us the same tools in our toolbox that the electric utilities have to propose different rate-making processes to the PUCN for their consideration. Now, Madam Chair, with your permission, I will walk through the bill and the proposed amendment that was posted online concurrently. If that is okay with you? I would like to point out that we proactively reached out to many stakeholders throughout this process, and this amendment reflects many of the concerns and feedback we have received on this bill. I also want to say that we're open to continued feedback and changes from stakeholders going forward. This amendment just reflects where we're at today in our discussions. Sections 3 through 10 include definitions used throughout the bill, but there are a few I would like to highlight for you. The earnings share mechanism is another significant benefit for our customers in this bill. This mechanism allows customers to share in the utility's earnings if it over-earns its authorized rate of return established by the PUCN. We do not have the ability to do this currently. Formula rates are rates based on a formula established by the PUCN to determine the rates utilities can charge customers, ensuring utilities receive costs or recover costs and earn a fair return while also considering customer affordability and financial stability. Performance-based rates are the approach to utility regulation that ties utility revenue and profits to specific performance goals rather than solely relying on traditional cost of service models. Many groups and stakeholders in this process have publicly supported performance-based rates for electric utilities. Section 11 requires the PUCN to adopt regulations to allow alternative rate-making applications for natural gas utilities and outlines the requirements of an alternative rate-making plan, including the mechanisms and customer education requirements. Additionally, the PUCN may require the natural gas utility to provide cost of service studies, as well as a comparison of charge rates versus revenue in both an alternative rate-making plan and under the existing rate-making process established by NRS, to ensure that customers of the utility are charged just and reasonable rates and benefit from lower regulatory administrative costs. Because balancing the interest of customers and shareholders is already contemplated in NRS, the PUC suggested striking the line in Section 11, sub 1G3 in the amendment. And Section 11 also clarifies that the PUCN is not required to accept applications to establish an alternative rate-making plan if it determines the plan is not consistent to the established criteria. So again, maintaining full control and authority over the process. In the amendment, the language at the end of Section 11, subsection 1C, was changed to state that the PUCN will determine how long until the utility has to file a general rate case rather than setting that number specifically in statute as drafted. There were also two NRS references in Section 11, subsections 1E and F, that were changed in the amendment. Also in the amendment, now Section 11, subsection 1H, is language from the original bill that was just moved from Section 12 into Section 11, again based on a suggestion from the PUCN that subsection fit better in Section 11. Section 12 allows for the PUCN to make a determination of the plan submitted by a utility. Going to the amendment, Section 12, subsection 1 states that the utility may apply for a alternative rate-making plan, but clarifies that it is not required to do so based on a suggestion by the other gas utility in the state. Another change in the amendment is in the amendment is in the section 12, subsection 1A, that states that the utility can file an alternative rate-making plan either during a general rate case or within 6 months after we receive a rate case ordered by the PUCN. An amendment that adds subsection 3A, an amendment was supposed to be added to include a new subsection 3A to section 12 to require a utility to hold multiple consumer sessions if it serves more than one major geographical area in the state. We made this change based on a suggestion by the Bureau of Consumer Protection. However, it was inadvertently excluded when we submitted a new version of the amendment, which we apologize for, but we want that to be on the record that it will be added back in. The amendment also adds a subsection 8 to section 12 that was requested by the other gas utility in the state that says if natural gas utility receives a revised order from the PUCN on an alternative rate-making plan, the utility is not required to go forward with the plan. The rest of section 12 requires the commission to only accept a plan that is in the public interest, results in just and reasonable rates, protects the interests of customers, and includes a customer education plan. It also outlines the criteria to be included, such as the earnings sharing mechanisms and considerations for capital expenditures and annual adjustments. Lastly, this section authorizes the commission at any time to investigate any of the rates, charges, rules, regulations, practices, or services related to the alternative rate-making plan. Section 13 clarifies that the bill does not limit the commission's existing rate-making authority. So that's an overview of the bill and the amendment. And before we turn it over to the questions, Madam Chair, if I may, I just wanted to reemphasize a few points. As you can see, I think very clearly in the language, nothing in this bill removes any of the PUCN's authority over our rate-making process. It does not issue Southwest Gas or any other natural gas utility a blank check to raise rates on its customers. It also closely mirrors SB 300 that was passed in 2019. That bill was passed nearly 6 years ago, has not resulted in any of the things that are being posted online about this bill. It also the bill does, all the bill does is allow us to apply to the PUCN for an alternative rate-making plan as part of a general rate case or within 6 months from when rates become effective. And again, allows the PUCN to determine how those rates are charged to customers. They can approve, modify, or outright deny the alternative rate-making plan, and if it is not in the best interest of our customers, as this bill requires it must be. Finally, you may hear testimony that the desire for natural gas utilities to go through the resource planning process required by SB 281 from last session before considering alternative rate making for gas utilities. However, due to the timing of when we must file our first resource plan, which is October 1st of this year, and the timing of the PUCN adopting regulations for this bill, an alternative rate-making plan couldn't realistically be filed for approximately 6 months to a year after we file our first resource plan. So there is ample time for that process to play out prior to an alternative rate-making plan being filed and considered by the PUCN. So thank you for your consideration of this bill and are happy to answer any questions you might have.
I just have a quick question when it comes to, you said that is the only proposed amendment that didn't make its way into this like amendment language has to do with section 12 and the notice in public hearings?
That's Scott Leadham for the record. Yes, that's correct. It would have been a new section A under section 12 sub 3 that would have said if a natural gas utility serves more than one geographical area in the state, it would hold a consumer session in each of those major geographical areas.
I don't have any further questions. Does anyone from the committee have any questions? Looks like we don't have any.
Great. Thank you very much.
Thank you. At this point, we will go to testimony in support of Senate Bill 417. If you can come to the table here either in Las Vegas or here in Carson City or in Las Vegas, I'd ask you to do so at this time. And go ahead and begin when you're ready. Again, you can always submit your written testimony and comments and further comments in writing. That is always available for anyone. Just a reminder. Go ahead, keep going.
Good evening, Chairwoman and members of the committee. For the record, my name is Nick Schneider, Director of Government Affairs for the Vegas Chamber, here in support of SB 417. Strong support as this would streamline the rate-making process. It saves administrative dollars. Also allows for more predictable pricing for our ratepayers, as well as just allows for improved service. And for those reasons, we do ask for your support, and thank you for your time and consideration.
Thank you, Madam Chair, members of the committee. For the record, my name is Terry Graves, representing Nevada Manufacturing Association. Manufacturers use considerable natural gas both for facility heating and in manufacturing processing. So we are encouraged that some cost savings could be realized from this, and the consistency of regulation is also of important interest to us. So for that, we do support SB 417. Thank you.
Good evening, Madam Chair, members of the committee. For the record, I'm Paul Enos. I'm the CEO of the Nevada Trucking Association, and I'd like to echo the comments from the previous testimony in support. We do think there's a cost savings. We do appreciate the predictability. Not only do we use natural gas to heat our facilities, but we also use it to run our trucks. You know, Nevada has been a leader in terms of natural gas trucks being on the road. In 2009, President Obama was here celebrating a national fleet employing the package vans down in Southern Nevada. So we do appreciate the potential cost savings and the predictability with this measure. Thank you.
Good evening, Chair Nguyen and members of the committee. For the record, my name is Chloe Chisholm with NV Energy here in support of SB 417 as amended. SB 417 provides natural gas utilities with the optional ability to pursue creative methods of rate setting while maintaining consumer protection and transparency. We believe alternative rate making can be a helpful tool for utilities to plan for the future and continue providing safe, affordable, and reliable service to our customers, and we're happy to support. Thank you for your time.
Thank you, Chair and members of the committee. Joe Hill, Policy Analyst with the Retail Association of Nevada. RAND supports SB 417, which modernizes how natural gas rates are set in Nevada. This bill helps make pricing more stable and predictable for businesses and consumers alike. Alternative rate making gives utilities more flexibility to manage costs without relying solely on rate hikes. It encourages energy efficiency, improves customer services, and reduces the need for frequent rate cases, all of which help lower costs that are passed on to consumers, including our retail members. We respectfully urge your support for SB 417. Thank you.
Good evening, Chair and members of the committee. My name is Peter Saba, S-A-B as in Bravo A, and I'm the Senior Government Affairs Manager for the Nevada Restaurant Association. Restaurants are energy-intensive businesses. We depend on natural gas for everything from cooking to heating. Predictable and stable utility costs are essential for us to operate efficiently, plan budgets, and stay competitive, especially in the challenging economic climate. This is particularly critical for small businesses like ours that operate on tight margins. We also value the bill's emphasis on customer education and protections, ensuring that any new rate structure serves the public interest and goes through a transparent approval process. SB 417 offers a modern, flexible approach to managing utility rates while preserving strong oversight by the Public Utilities Commission of Nevada. Thank you.
Good evening. My name is Tia Smith, T-I-A-S-M-I-T-H. I'm a policy attorney with ACLU of Nevada. We support this bill and we urge the committee to support it as well. Thank you.
If we can go down to Las Vegas, go ahead and begin when you're ready.
Thank you, Chair and members of the committee. My name is Emily Osterberg, O-S-T-E-R-B-E-R-G, and I'm here representing the Henderson Chamber of Commerce and our over 2,000 members. We're here to express our support for SB 417. This legislation represents a forward-thinking and much-needed modernization of Nevada's regulatory framework for natural gas utilities. Under the traditional rate-making model, utilities are constrained to infrequent, costly, and often reactive general rate cases. SB 417 offers a solution by authorizing the Commission to approve alternative mechanisms that allow utilities to set rates based on forward-looking plans that make pricing more predictable while ensuring oversight, accountability, and consumer protection. For these reasons, we support SB 417. Thank you.
I don't see anyone else in person. If we can go to the phone lines in support of Senate Bill 417.
To testify in support on SB 417, please press star 9 on your phone to take your place in the queue. Caller, you're unmuted and you may begin. Caller with the last 3 digits, 552, you are unmuted and you may begin. Caller with the last 3 digits, 552, please press star 6 to unmute yourself. Once again, caller with the last three digits, 552, please press star 6 to unmute yourself. Chair, it seems like that caller is having difficulties to unmute. Would you like to proceed to the next one?
Yes, let's go ahead and proceed to the next one, and we'll see if we can come back to that person.
Good evening, Chair Wynn, Vice Chair Pazina, members of the committee. My name is Chandler Cooks, ChandlerCooks, on behalf of the Urban Chamber of Commerce. Our predictability is everything in business, and we support SB 417 because it offers a pathway to more stable, transparent utility costs, which is a critical factor for Nevada's small businesses. We also believe that this will improve cost predictability. Thank you so much, and we urge for your support.
Thank you. If we can go to the next caller.
Good afternoon, committee. My name is Mary Wagner for the record. That is MaryWagner. And I'm here today on behalf of Moms Canary Force and Eco Madres in strong support, in strong opposition to SB 417, Nevada Family.
I'm sorry, right now, excuse me. We are in supportive testimony of Senate Bill 417. If you could just go back into the queue.
I do apologize. I'm so sorry.
That's okay. Do we have any other callers in support of Senate Bill 417?
Chair, there are no more callers in support at this time.
Okay, next I will go to testimony in opposition of 417 here in person. So if you could come up to the table and go ahead and begin when you're ready.
Good afternoon, Chair and Vice Chair. For the record, my name is Ernest Figueroa. I'm the Consumer Advocate and Chief Deputy Attorney General in the Bureau of Consumer Protection. With me is a Regulatory Manager, Nicole Orr, also with the Bureau of Consumer Protection. I'm here to testify in opposition of Senate Bill 417. And the reason why is basically it is not a mere matter of SB 300. There are some significant differences that cause me some concern. I'm just going to lay them out here for you for your edification. First, for example, in the amendment that was discussed is Section 11G. It excludes the phrase aligns an economically viable utility model with state public policy goals. That was included in SB 300. It's conveniently absent in this bill. In addition, this SB 417 contains Section 11H and Sections 11H1 and H2 and Sections 12A. All of these provisions here basically have to do with additional criteria for formula rates that was not included in SB 300. And it is my belief that this inclusion basically unfairly tips the scales in the utility's favor to the detriment of the ratepayer. If there were some additional amendments that could be considered for the benefit of the ratepayer to help tilt the scale back, perhaps that would remove my opposition to the bill. But at this point, I remain in opposition, and I look forward to further discussions with the bill sponsor to see if we can come to some sort of consensus. Thank you.
Good evening, Chair and members of the committee. For the record, my name is Christy Cabrera-Georgeson. I'm the Deputy Director of the Nevada Conservation League, and we are here in opposition of SB 417. The formula rates and multi-year rates plans proposed in this bill are typically a bad deal for customers as they remove PUC and oversight from utility rates and incentivize utilities to overinvest in their systems. In 2023, the legislature passed SB 218 to establish an Integrated Resource Plan, or IRP, for gas utilities. As you've heard, Southwest Gas will file its first gas IRP this summer, a significant step towards long-term transparency and planning. We should allow that process to fully play out and be evaluated before even considering an alternative rate-making mechanism as proposed in this bill. Additionally, there have been some conversations about how this is similar to SB 300. It is not a parallel or equivalent to that bill, as you had just heard. The structure, purpose, and context of the two bills differ significantly, and gas utilities are fundamentally different from electric utilities in their decarbonization, energy efficiency, and affordability pathways. SB 300 intentionally did not include gas utilities because of those reasons. It's just not a one-size-fits-all model. Additionally, SB 300 maintained strong regulatory guardrails, including annual cost reviews, consumer sessions, and a narrow scope focused on performance-based clean energy outcomes. SB 417 would allow major rate changes outside of general rate cases, weakening oversight and reducing opportunities for stakeholder and public input. Decision makers must prioritize affordability and strong oversight in any utility rate reform and reject efforts to expand regulatory flexibility for gas utilities without clear, enforceable consumer benefits. This is not the time to give gas utilities more tools to raise rates with less scrutiny. Nevadans need protection from higher energy costs and meaningful progress towards a cleaner, more affordable energy future. We urge the committee to oppose this bill. Thank you.
Hello, Chair and members of the committee. My name is Jamarion Williams. I'm the Government Affairs Manager for Western Resource Advocates. Western Resource Advocates is a nonprofit conservation group that works for common sense solutions that protect our land, air, and water resources. WRA also intervenes in general rate cases and integrated resource planning proceedings for both gas and electric utilities at the Commission, representing and advocating for the interest of everyday Nevadans. WRA opposes SB 417 primarily because it removes Commission oversight from natural gas utilities and would allow the utility to add investments that may not be warranted or in the best interest of Nevadans into the general rate base that customers eventually pay via their bills. General rate cases are structured to act as safeguards for customers and shelter them from unneeded investments the utility may choose to pursue to increase their profits. In general rate cases, the Commission looks at actual utility expenses in a 12-month period to base rates on, and interveners as well as regulatory staff in the BCP have the opportunity to dispute those costs, question if they are warranted, and argue that customers shouldn't be responsible if the utility acted improperly. Implementing an alternative rate-making plan, and specifically one that included any possibility of formula rates, removes the ability of the Commission and interveners to examine if the utility is truly making need in prudent investments to serve their customers. Under this bill, an alternative rate-making plan would preclude a gas utility from needing to file a general rate case for an extended period of time. This is a large amount of time for rate structures and costs of service allocations of who pays what to remain unchanged and unexamined for fairness. WRA urges members to oppose SB 417.
Thank you, Chair Nguyen and members of the committee. My name is Caitlin Gatchenyan, and I serve as the Nevada representative for Southwest Energy Efficiency Project, or SWEEP. We respectfully oppose SB 417 and urge a no vote on this bill. This bill would allow gas utilities to pursue alternative rate-making mechanisms such as formula rates before the gas integrated resource planning process established by this legislature in 2023 has even had the chance to begin with. The first gas IRPs are due October 1st, 2025, and they will provide the Public Utilities Commission of Nevada with the necessary framework to assess future gas usage and ensure utility investment align with Nevada's policy goals. Authorizing alternative rate making before this foundational process plays out could result in premature or misaligned utility investments, especially as gas usage declines and electrification and efficiency improve. Unlike its electric counterparts, SB 417 lacks important consumer safeguards and criteria to ensure alignment with state energy policy. For these reasons, SWEEP urges your opposition. For more information, SWEEP has also provided a technical letter and exhibit. Thank you for your time and consideration.
Hello, Chair Wynn, Vice Chair Pazina, and members of the committee. My name is Julia Hubbard, and I'm the Nevada Program Director of Solar United Neighbors Action. While we help people go solar, we also believe in a fair energy system where consumers are educated and protected and utilities are held accountable. We represent the needs and interests of almost 125,000 solar owners. We respectfully oppose SB 417 as it does not represent the needs of ratepayers. This bill seeks to fast-track planning and bypass the Public Utility Commission's and consumer advocates' review. From the last session, SB 281 aims to improve transparency and establish a planning process for gas utilities. The first IRP will be filed this fall. The state and public need time for this process to take effect. Long-term planning on gas infrastructure will have an impact on rate making across the board. In other states like Maryland and Arizona, we have already seen negative impacts of similar policies. Studies show these policies resulted in increased rates for consumers, not savings for ratepayers. I will also just echo the remarks that SB 300 had guardrails, so this is not a one-to-one comparison. At a time when costs are already sky high and uncertainty is all around us, we should be focusing our efforts on lowering utility bills, not removing critical oversight processes that protect consumers and ensure that utility spending is checked. Thank you for your time.
Thank you, Chair and members of the committee. My name is Olivia Tanager. Again, for the record, I'm the director of the Sierra Club's Toyabe chapter. We're the largest grassroots environmental organization in the great state of Nevada. My colleagues have eloquently outlined a couple of the points that I wanted to make, so I'm just going to go ahead and ditto, but you heard that multi-year rate plans used in other states were linked with increasing costs, and then you heard about the differences between SB 300 in 2019 and this bill now, including, importantly, the guardrails that existed in SB 300 in 2019 that do not exist in this bill in its current iteration or with any of the proposed amendments. So with that, the Sierra Club is in opposition and urges a no vote on this bill. Thank you.
We can go to Las Vegas. Go ahead and begin when you're ready.
Good evening, Chair and members of the committee. My name is Hector Arreola, last name Arreola, and I am the Policy Fellow with the Nevada Environmental Justice Coalition, and I just want to ditto everything that everyone has mentioned, and also just really emphasize that Nevadans are already facing skyrocketing utility costs, and our communities cannot afford this bill to be passed, and we just urge the committee to prioritize the people of Nevada and vote no. And thank you for your time.
Now if we can go to the phone lines for testimony in opposition of Senate Bill 417. I know we have at
To
least one
testify
person.
in opposition, please press star 9 on your phone to take your place in the queue.
Good evening, everyone. CYRUS, HOJJATY. I stand in opposition. I will ditto the previous callers. There's a lot of good things I like about this bill, but I just feel like there's just too much risk and potential concern. So please make some changes. Yield my time.
Next caller, please.
Good evening, Chair Wynn and members of the committee. My name is Barry Levinson. I am a resident of Reno and a volunteer member of an energy coalition that works to support good energy regulations at the PUCN and at local municipalities. I'm speaking today in strong opposition to SB 417. Our energy coalition has been working with a consummate energy expert, John Wellinghoff, who is very opposed to this bill. John has had many decades of experience with energy policy, including being Nevada's first consumer advocate in the Attorney General's office. He was general counsel to the Nevada PUC, and he served 7 years as commissioner on the Federal Energy Regulatory Commission, or FERC, 5 of those years as chairman. He is also the author of numerous articles on Nevada utility legislation, including the Integrated Resource Planning Act and the Deferred Energy Statute. Unfortunately, John is unable to testify today, so I am bringing you his comments as follows. It is John's opinion that, quote, giving Southwest Gas the right to have their rates set on a future test year with estimates of costs used to set rates charged to customers rather than using actual known and experienced expenses will definitely drive up costs for consumers. It will also set a dangerous precedent for future legislative proposals by NV Energy to do the same thing. We do not want our rates to skyrocket like they have in California, end quote. He also feels that if the legislature wants to consider real utility rate reform, then it should put some teeth in the performance-based regulation legislation, SB 300 from 2019, and make it mandatory rather than voluntary on the part of the utility. I join with John Willinghoff in opposing this bad bill and hope that the committee declines to pass it. Thank you very much.
Hello, Chair Nguyen, Vice Chair Pazina, and members of the committee. My name is Ariel Santiago, and I'm with Conservatives for Responsible Stewardship. CRS has members in Nevada that have consistently seen Southwest gas rate hikes year over year, even when the utility has exceeded its profit projections. In fact, this monopoly utility is one of the most aggressive at raising customer rates. Last year, it saw and was granted a record $59 million rate hike on its Nevada customers, despite the company reporting a record 12-month operating margin. A proposal similar to SB 417 is being implemented in Arizona, and Southwest Gas customers there are facing the consequences. An independent economist testified before the Arizona Corporation Commission and noted that historically, quote, formula rate plans have resulted in large rate increases with very few rate decreases and no measurable improvement in reliability of service, end quote. This bill removes needed PUCN oversight from gas utility rates and incentivizes Southwest Gas to overinvest in their systems because they can more easily pass that cost directly to ratepayers. So while Nevadans will keep getting hammered by higher and higher gas bills, Southwest Gas officers and shareholders, most of who reside outside of Nevada, will keep getting richer and richer on the backs of Nevada customers. On behalf of our Nevada members and in accordance with our organization's free market beliefs, I urge this committee to oppose Senate Bill 417. Thank you.
Good afternoon. My name is Paulette Henriad, Paulettete, last name Henriod. I am representing Mormon Women for Ethical Government, Nevada, or MWEG for short. Our organization respectfully opposes SB 417 as unnecessary and potentially detrimental to ratepayers in Nevada. We are aware of negative effects that similar formulary policies have had in other states like Maryland and Ohio, and we have worked on this issue in Arizona and have seen the evidence that these formula rate plans have resulted in large rate increases. So we encourage you to oppose SB 417. Thank you. Good afternoon, Chair and committee members. My name is Mary Wagner, for the record. That is MaryWagner, and I'm here today on behalf of Moms Clean Air Force and Ecomadres in strong opposition to SB 417. Nevada families are facing an affordability crisis. The cost of living continues to rise, especially when it comes to our utility bills. Our budgets are stretched thin, and we're working harder than ever to make every dollar count. Now is not the time to make it easier for Southwest Gas to raise rates with less oversight. Every dollar matters, every bill matters, every essential need matters. Utility decisions must be reviewed with care to ensure that consumers aren't being asked to pay more than what is fair. We respectfully urge lawmakers to reject SB 417. Please put the affordability and stability of Nevada families first. Reject policies that reduce oversight and increase the risk of higher bills. Thank you for your time.
Good evening, members of the committee. My name is Audrey Pearl for the record, and I'm the program director for Chispa, Nevada. We are in strong opposition of SB 417. Nevada families are struggling with unaffordable utility bills. This is one of the top issues we hear about from our community regularly, how utility bills have risen too high, become unpredictable, and are causing families to go without food or medicine to maintain basic services. We hear these stories from our members every week. We don't understand why Southwest Gas is proposing that the legislature, instead of the Public Utilities Commission, adopt alternative rate structures, when what we really need is immediate relief to lower our gas bills. Chispa, Nevada has conducted official polls of Southern and Northern Nevada, as well as surveys of our members across the state, and it is clear that lower utility bills is one of the community's highest priorities. What we see in this bill makes the rate-making process less transparent, allowing utilities to get approval for major expenses without community input at the PUC. It's already hard enough for our community members to understand what's happening with our rates. This bill would make it even harder. Under this bill, instead of having to defend before the PUC any quarterly or annual increases, Southwest Gas would be allowed to fast-track plans for years to come. This locks us into more pollution, worse air quality, and higher gas rates for years at a time. Of course, utilities want to get immediate approval for infrastructure upgrades, but that doesn't mean that it's the best interest of their customers who don't have a choice in their gas or electricity provider. SB 417 goes against what Nevada's want and need: more transparency in rate making, more accountability for corporate utilities, raising our rates, and lower bills for our families. Please reject this bill. Thank you.
Good afternoon, committee. My name is Shonda Johnson, SHAUNDA JOHNSON. I'm here on behalf of Faith in Action Nevada, and we oppose SB 417. As elected leaders, you must first ask yourselves how this impacts your constituents. Everyday Nevadans can't shop around for a better gas company. We're stuck with a monopoly, and that's exactly why we have the Public Utilities Commission of Nevada. It's the PUCN's job to scrutinize utility spending, determine prudence, and protect the public from unjustified rate hikes. But it's the legislature's job to ensure the regulatory oversight is strong and that utilities don't sidestep accountability. SB 417 would allow Southwest Gas to bypass the full scrutiny of general rate cases just because it's more favorable to them, and instead pursue rate setting through mechanisms that reduce transparency and limit public input. That's not accountability. That's giving a profit-driven monopoly more power while working families foot the bill. Please reject SB 417. Thank you.
Hello, Chair Wynn. This is Peter Guzman, President of the Latin Chamber of Commerce. I was the one having a phone problem. I would like to be in support of this bill. May I proceed?
Yes, go ahead and proceed. Thank you for calling back.
Thank you so much. Thank you so much. We are in full support here at the Latin Chamber of Commerce because we believe instead of just raising prices when costs go up, this approach allows utilities to use different tools to make pricing more predictable. It also can help utilities focus on things like improving service and encouraging energy efficiency rather than just covering costs. It also gives utilities more flexibility while still protecting customers. For those reasons and many more, we are in full support here at the Latin Chamber of Commerce of SB 417. Thank you for your consideration.
Sure, there are no more callers in support. Opposition at this time.
Thank you. Next, if we can go to testimony in neutral. We'll start on the phone lines, actually. Is there anyone to testify in neutral on the phone lines?
Chair, there are no callers in neutral at this time.
Thank you. We will go here in person. I don't see anyone in Las Vegas, so we will start here. And I see that PUCN has arrived, so please go ahead.
Thank you, Chair Wynn and members of the committee. Garrett Weir, Garrettweir. I'm General Counsel for the Public Utilities Commission of Nevada. I would just like to briefly express the PUC's appreciation for the early and consistent outreach from Southwest Gas and for the incorporation of the Commission's feedback into the language of the bill. And then also, I'd like to make myself available to answer any questions that the committee may have regarding implementation of the bill, including what the bill does or doesn't do. Thanks.
I do have a question. You know, we heard a lot about comparisons to the bill in SB 300, that's it. As it similarly situated types of things were in play for the other utility. And so I'm curious in your conversations and your reading of this bill with the amended language, if you believe this bill lacks the guardrails that exist in Senate Bill 300.
For the record, Garrett Weir. I'm actually not sure exactly what the reference is to guardrails. I think that folks might be referring to guardrails that were implemented via regulation by the Commission for SB 300, which provides for alternative rate making for electric utilities. So there are robust regulations that were adopted by the Commission via rulemaking, and it took quite some time for SB 300. I would anticipate that similar regulations that have similar guardrails would be established by the Commission. It's also worth noting this legislation does not contemplate approving or granting authority to gas utilities to immediately start using an alternative rate making plan. It merely allows those utilities to apply for permission from the Commission to even establish a plan. So there would still be a contested proceeding where in the regulations established by the Commission for SB 300, it more explicitly contemplates this. Even the language in this bill describes simultaneously filing a general rate case or very soon thereafter filing, that there being close proximity in time for when they're filed, so that the Commission can compare the traditional cost of service-based general rate case outcome to the outcome of the proposed alternative rate-making plan. And so this is something that the Commission would have full authority to approve, not approve, modify, but ultimately the Commission would still have the obligation to ensure that any rates adopted pursuant to this statute, that those were just and reasonable and in the public interest.
So some of those comments that we heard during the opposition testimony about how some of the things that are in there, they were never in statute, they were promulgated through rulemaking through the PUCN?
For the record, Garrett Weir. So the consumer advocate spoke previously and did identify a couple of distinctions where there are differences. One being this bill does not contain the requirement for the plan to, I think, something along the lines of advancing the policies of the state. I think language to that effect. That would be one distinction. I think a lot of the focus of that, or the intent of the inclusion of that in the SB 300 language, was related to renewable portfolio standards, things associated with the goals of decarbonizing the electric generation fleet. But that is a difference that exists. Also, there is some language that is more explicit in contemplating one of the possible methodologies for formula rates. Again, my interpretation of that is that it's merely illustrative. It doesn't require the Commission to adopt it. It's one of countless numbers of methodologies that could be considered.
The distinction that you just made in that first thing, that would make sense because our electric utilities have more options, I guess, to include in their portfolio, whereas natural gas, there aren't other options. Is that correct? You wouldn't have a similar language when it came to natural gas?
For the record, Garrett,
Or is there something I'm not aware of?
well, so there are public policy programs associated with natural gas service, renewable natural gas, conservation and energy efficiency programs, but there are certainly far more programs associated with electric utility service.
Does anyone know? Go ahead, Senator Hansen.
Thanks, Madam Chair. Is there anything in this bill that allows a utility company to either bypass you guys in any way, shape, or form, or allows them almost like a veto over any decisions that the PUC makes?
For the record, Garrett Weir, it allows the utility to apply for certain things that would reduce the frequency of having to come in for a full cost of service based, auditing and setting of rates in that way. I think certainly it wouldn't bypass the commission's authority. The commission could at any time adjust the rates to bring them in line with cost of service based rate making. The regulations that were adopted for SB 300 contemplate a lot of scenarios where the commission or other entities could trigger the need to compare the alternative rate making plan or the results of it to what would occur under the traditional cost of service based rate making. So ultimately the commission would have authority to make sure that those rates are not harming customers.
Okay, no, that was kind of the impression I got from hearing, especially the opposition testimony, was that this almost allows like a bypass process or allows the energy company to come up with some unique alternative that you guys have to live with the alternative rather than look at everything. So what you just said, that's not accurate. You guys always still have full oversight over any cost increase or anything like that proposed by utility company, correct?
For the record, Garrett, that's our interpretation, is that this in no way infringes upon the commission's plenary rate-making authority for utility companies. If we thought otherwise, we wouldn't be in the neutral position. We'd be opposed to this bill.
Very good. Thanks, Madam Chair.
Do we have any other questions? Seeing none, thank you so much for that clarification. I don't see anyone else. I think we already did phone lines in neutral. So with that, I will close neutral testimony. And if we can call the bill sponsors up, if you'd like to make any closing statements. You don't have to, but you can.
Scott Leadham for the record. I will be very brief. Just to clarify some of the questions that have already been asked, this bill does not seek for any kind of fast tracking of an alternative rate making plan. It's the same process set up for the electric utilities in Senate Bill 300. Again, unsure of where people think the lack of guardrails are in this or oversight. Again, following the same process as set up by SB 300. There's some mention of formula rates being applied for in Arizona. We are the largest gas utility in Arizona. We have not filed an alternative rate making plan or formula rates in Arizona, so not sure where that is coming from. Also, there's no future test year proposed in this bill. It's not defined in this bill. And finally, as you've heard from Mr. Weir and others, nothing in this bill takes any authority away from the PUCN to make any decisions on any current rate making or alternative rate making plan, and it's part of a general rate case or otherwise. So with that, I'll close my comments.
Can I ask you one follow-up question? There was opposition testimony that talked about, you had alluded to the Arizona, I guess, model or the law that's in place. Can you, I don't know if you can briefly, but can you describe, is this the same model that, I mean, you indicated you're the largest natural gas utility in Arizona. Is this a similar bill or is this different? Or can you make that distinction between how this differs from what exists in Arizona?
Absolutely. Scott Leadham for the record, and I'll try to do it briefly, but Arizona is set up quite a bit differently than Nevada in terms of the way it regulates utilities. It does have a Public Utilities Commission, although it's called the Arizona Corporation Commission. It is an elected body, not appointed. And also they set and implement energy policy. The ACC does in Arizona. Here, the Nevada Legislature sets energy policy, the PUCN implements it. In Arizona, they both set energy policy and implement it. Some call them a fourth branch of government. I don't know if that's a joke or what, but they're the ones that set energy policy. They recently set or made a policy decision to allow utilities to do formula rates. Again, that wasn't a bill, that wasn't legislation, that's something that the ACC decided to do on their own. So there is the ability for one of the alternative rate-making mechanisms to exist in Arizona now, but again, we have not filed a formula rate plan in Arizona, and I'm not aware of any other utility that has done so yet either. I hope that answers your question.
I don't think we have any other questions. Thank you so much. And at this time, I will close the hearing on Senate Bill 417. And that brings us to our last item in the agenda. Thank you, everyone on this committee, for your patience in getting through all 5 of these bills. Public comment. Do we see anyone to come and testify in public comment? Seeing no one here in Carson City or in Las Vegas, if we can go to the phone lines for public comment.
If you'd like to participate in public comment, please press star 9 on your phone to take your place in the queue. Chair, the public line is open and working. However, there are no callers at this time.
Thank you. And at that time, I will close public comment, and meeting is adjourned until Wednesday.